while the clerk calls the roll.
Thank you, Mr. Chairman. Mr. Kelly.
Here.
Mr. Akers.
Here.
Mr. Fluharty.
Here.
Mr. Foster.
Here.
Mr. Garcia.
Here.
Mr. Hanson.
Here.
Mr. Heckert.
Here.
Mr. Hillenbrand.
Here.
Mrs. Kimball.
Present.
Mr. Kirby.
Here.
Mr. Kump.
Yo.
Mr. Mallow.
Here.
Mr. Marple.
Here.
Mr. Martin.
Here.
Mr. Nestor. Mr. Phillips.
Here.
Mr. Pritt. Mr. Ridenauer. Mr. Shamblin.
Here.
Mr. Steele.
Here.
Mr. Ward.
Here.
Ms. Warner.
Here.
Mr. Westfall.
Here.
Mr. Zetezelo. And Mr. Chairman.
Present. We do have a quorum. Any additions or corrections to the minutes? If not, I call upon the Vice Chairman for a motion.
Thank you, Mr. Chairman. I move to adopt the minutes of the January 17th, 2024 meeting.
You heard gentleman's motion. Discussion? If not, all in favor signify by saying aye. Aye. Opposed, no. The ayes have it. The minutes for the last meeting are approved. Ladies and gentlemen, we're going to skip around a little bit. Council is making some final edits to one of the bills that's on the agenda. So we are going to start actually with what is item number 7 on your bill, 4205. And Council, when you are ready, you may present the bill.
Thank you, Mr. Chairman. This is a fairly straightforward bill, one of those where the short title related to changing standing for election litigation is exactly what it does. It provides 3 separate new provisions to Section 3145 dealing chiefly with who has standing in election cases. The first provision, a new sub B, provides that the legislature has legal standing to bring an action against any state government official who makes or attempts to make unauthorized changes in election laws or rules, or who attempts to waive such laws or rules. The second prong, sub C, provides that the legislature is a necessary party in any suit against a state agency or official contesting the legality or constitutionality of an election law or regulation, or involving any illegal or unauthorized changes to such law. And there's a new sub D providing that any individual who is validly registered to vote in West Virginia may file a writ of mandamus in accordance with state law governing such writs against any state or local official who fails to abide by or enforce an election law or regulatory requirement, so long as such writ is filed within 30 days of the conclusion of tabulation of votes. Those are essentially the changes made to this section. I'll answer any questions from the committee.
Thank you, Council. Are there questions of Council regarding this bill? Any questions of Council? Gentleman from Marion.
Thank you, Mr. Chairman. Council, in subparagraph D, the paragraph that gives standing to any registered West Virginian to file writ of mandamus, it says against any state or local officials. So does that mean that an individual, let's say I live in Marion County and I'm a registered voter there, could I do a mandamus against an issue arising in Mercer County?
The way that I read it, the gentleman is correct. I think that the way that the gentleman reads it, so long as your suit was predicated upon the idea that you were acting to enforce a state election law or regulatory requirement, which was binding statewide, it involved, as we would say, a general application. So long as you were attempting to enforce a state election law or regulatory requirement that's not directed at a particular county outcome, so long as you're attempting to enforce that law or force them to abide by that law, yes, I think the gentleman is correct.
Wouldn't have to be a specific case or controversy, though?
I think you would be initiating the case or controversy by the filing of a petition for writ of mandamus.
But you're specifically trying to, it's not a declaratory action, it's an action against an election official.
Yes.
Or someone who is trying to act according to state law, but that somebody that may not be anywhere close to where you are or have anything to do with your ability to vote in an election.
That's correct.
And I see that as a little different. The legislature, on the other hand, I don't know that I agree with this yet. I'll continue to review, but the legislature has acted in the law, but usually you'd have to have, to have standing, you'd have to have, your vote would have to matter in the case or controversy.
Yes, and I mean, I think, we could argue that there are instances where our vote would matter in a vote cast in another county, statewide office, for example. But for votes cast in a purely local or county election, it's very difficult to see how that would accord with our traditional views.
I guess you could have a scenario where you have an individual, and just not to try to be too negative, I mean, somebody who maybe cares about politics a lot and starts filing lawsuits all over the state of West Virginia based on trying to nitpick certain things. That's different than somebody who, again, has in a local election especially, their vote matters within the outcome. But you have somebody that could be more of an agitator, just starts filing lawsuits all across the state.
I can't deny the gentleman's point under the way that the statute reads.
And they could not do that now.
They could not do that now.
Okay, thank you. Thank you, Mr. Chairman.
Other questions of council? Gentleman from the 79th.
Thank you, Chair. Thank you. After the 2020 election, there were 7 states that created and submitted fraudulent certificates of ascertainment that asserted that Trump had won the Electoral College in those states, the so-called fake electors. Are those covered by this bill? In other words, if there was anybody who, in the entire state, that wanted to raise an issue related to fake electors, if those happened in West Virginia, would they have a cause of action?
Well, yes, I think under that scenario, yes, I think any citizen registered to vote under sub D of this could have filed to prevent such an action if such an action were undertaken in West Virginia.
Okay. Thank you. Thank you, Mr. Chair.
Other questions of council? Question of council. Gentleman from the 5th.
He took my first question. So, can you give me an example of what an attempt to make unauthorized changes in state election laws and state rules looks like?
I think that it would be if we had a situation where a official attempted to waive registration deadlines, waive deadlines for absentee voting, waive deadlines for their seat, if they attempted to hold a canvass at a later date so the votes could be received. I mean, I'm just thinking off the top of my head here of situations where I can think of, what an attempt to make an unauthorized change in a state election law would be. Obviously, as the gentleman's aware, those all come with hard and fast deadlines.
Well,
And if they attempted to waive those deadlines unilaterally, that's an example that I can think of. That would be an unauthorized change in election law. If they attempted to keep a polling place open later than polling hours.
Okay.
Things of that nature, I think,
All
would
right,
be one to
so
contemplate.
the things of that nature you're describing, do we have an example or a ballpark number of how many such attempts have been made in West Virginia in the past
I'm not aware of any.
few years?
We
You're
have
not
a
aware of
representative
any?
from the Secretary's office here. It could probably get better data on that, but I'm not aware of any.
Probably no data, because it's highly unlikely that it's occurring. As for the legislature being deemed a necessary party, how does that work? Who represents the legislature in this suit?
The legislature would have its ability to pick its own counsel in such an instance.
Well, okay, so who would represent the picking council? I understand, but for instance, is there a 30B rep? Is there an individual who gets designated to represent the legislature in this lawsuit?
I think in the past, the legislature, when it's had to be represented as a party to an action, has usually selected its own firm or party to represent it. I'm not the guy who makes that decision. So, but that's usually been in the past. They have selected a firm or selected counsel to represent them.
Okay, I understand selecting counsel. I'm asking who is the designated rep for the legislature itself? Would it be an elected official serving in the legislature?
Usually it's the Speaker and President of the Senate who are the designated
so
officials for the legislature.
If all these lawsuits are filed, as was described by the minority chair, would then the Speaker or a designated individual, like the President of the Senate, be forced to represent the legislature in all these lawsuits?
If they were a necessary party in any lawsuit, yes.
Okay, so a scenario would arise where the Speaker of the House, Senate President, instead of doing their due diligence and duties outside of legislative session, could then be brought into court to represent the legislature on multiple lawsuits that may be filed.
Well, again, I think the gentleman's correct. They would be brought in, but they would be brought in via counsel. I don't think, a Senate President is certainly not, licensed to represent the Senate in court.
Well, potentially
The
they'd have
Speaker
to
is, but that's only an accident of who our Speaker is at the present time.
potentially they'd have to sit for a deposition.
Yes.
Okay, so back to my premise. A representative of the legislature, be it the Speaker or Senate President, may have to sit for multiple depositions if this were enacted, correct?
Yes, although my understanding is, as with yourself, they would not have to take part in court proceedings during the active sitting of the legislature. I think code would exempt them from taking part in court proceedings during the pendency of the legislature, but they could be compelled to sit at other times.
Finally, in subsection D, where we talk about this writ of mandamus, and it states that it's against any state or local official who fails to abide by or enforce state election law regulatory requirement. It's by anybody who allegedly. So there's no finding that has to happen before this lawsuit is filed, correct?
Gentleman's correct.
Okay, so it's allegedly. So back to the minority chair's point, anybody who's validly registered to vote, how many people is that in the state of West Virginia?
I think about 1.1 million, if I recall correctly, or 1.2 million. I'm not sure the exact figure, but again, we have somebody here from the Secretary's office who can give you more up-to-the-minute data than I.
So we have potentially 1.1 litigants available to us in the
Yes,
state
sir.
of West Virginia
Absolutely.
who could file against any state or local official for allegedly not abiding by or enforcing state election law regulatory requirement.
Gentleman's absolutely correct.
I thought so. Thank you.
Other questions of council? Questions of council? Does any member desire leave to call a technical witness? Gentleman from the 5th.
Here from the Secretary of State's office.
Gentleman Deke Kersey, do you mind taking the podium behind you? Raise your right hand and swear in. Do you swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Gentleman from the 5th.
Thank you, Mr. Chairman. Thank you for being here. You heard my line of questioning. I'm not going to get into the weeds on this, but can you give us a ballpark number on how many attempts to make unauthorized changes in state election laws or state rules have occurred in the past few years?
In West Virginia, I'm not aware of any.
So that's zero?
In West Virginia, yes.
Okay, zero. And how many registered voters are there in the state of West Virginia?
Just shy of 1.2 million.
And you heard my questioning where council agreed with me that potentially 1.2 million or just shy potential litigants will be part of this legislation. Is that concerning for Secretary of State's office?
Well, if I'm able to answer that question, if the Secretary of State's office breaks the law, I hope that all 1.2 million sue us.
But as was stated on the record here previously, it's more than just the Secretary of State's office that would be privy to this lawsuit.
If any election official is sideways with election law, I would hope that they're held accountable.
Thank you.
Other questions, Mr. Kersey? Gentleman from the 79th. 6th, sorry.
Thank you, Mr. Chairman. Mr. Kersey, thank you for being here. If someone were to bring a mandamus action now that had standing in the state of West Virginia, is an individual able to get their attorney's fees if they're successful in their lawsuit?
We've been the necessary party on several mandamus cases. I don't recall attorney's fees being part of that, but they very well could be.
I'm just wondering if someone could file a lawsuit and then they could have a recovery of their attorney's fees. Okay. Thank you, sir. Thank you, Mr. Chairman.
Gentleman from the 79th, followed by the gentleman from the 88th.
Thank you, Mr. Chair. You mentioned that if somebody breaks an election law, they should certainly be held accountable, and I would assume that everybody here agrees with that. Under current law, let's just say somebody broke an election law in my county, in Monongalia County, for a local election. How would they be held accountable under current law?
Well, it depends how it's brought about, but the typical process through our office would be we get a formal complaint, we investigate it through our investigations division, and then if we find that there seems to be probable cause a crime occurred, statute requires that we refer that to a prosecuting attorney who can then file a criminal complaint or take it to a grand jury.
And would that complaint need to come from somebody in Monongalia County, or could it come from anybody?
This is a prosecutor question, but I believe the criminal complaint can be filed by anybody with the state police or the prosecutor himself, or local law enforcement. Sheriff's departments do criminal complaints as well.
Okay. Could you give an estimate of roughly how many different people have the ability to file such a complaint?
Well, criminal complaint, which is separate from the mandamus, would be law enforcement. I believe you have to be an active law enforcement officer or statutorily authorized to do it like a prosecuting attorney. I don't want to speak out of turn here. I'm not a prosecuting attorney or criminal law expert.
What about a mandamus? Who could file that under current law?
Someone with standing. It's a civil action, so anybody with standing.
So who would have standing for a case in Monongalia County?
Right now, it would be an affected voter. So if there's an action in Monongalia County contemplated under the bill where someone violated an election law allegedly, it would be a Monongalia County voter right now.
So in my county, there already are tens of thousands of people who have standing in such a case.
Presuming they're harmed, yes.
Okay, thank you. Thank you, Mr. Chair.
Gentleman from the 88th.
Thank you, Mr. Chairman. Thank you, Mr. Kersey, for being here. In your experience, do we tend to make laws in advance of offenses against those laws?
I think that the legislature, in its wisdom, is proactive in its approach to legislation.
Thank you. Appreciate that answer. So, in your knowledge, to your knowledge, the issue that I think is trying to be addressed by this bill here, is there any experience in other states that may have brought this up?
I can speak to experiences in other states that I have researched through my professional capacity. I don't know if it was the impetus for the legislation, but yes.
All right. Thank you very much.
Thank you. Gentleman from the 5th, second time.
Chairman, very quickly, during the pandemic, we moved dates. I'm not allowed to say we, the state of West Virginia, I believe through the governor's office, moved dates and reacted to the pandemic, and it had an impact on our elections and certain deadlines and things of that nature. That was not through legislative action. If this bill were enacted, you as the Secretary of State or the governor's office would not be able to do that, correct?
No, I disagree.
You disagree with that? Why?
Yes. The governor's authorization in current code was given by the legislature to do things like issue a state of emergency for various reasons. And when he issues a state of emergency, depending on the reason, it authorizes other things, such as relaxing certain statutory requirements that couldn't be followed because of the state of emergency. COVID itself being very specific to in-person interactions, where the governor said, you have to stay at home now. I'm telling you, you have to stay at home for the safety of the public. Well, Election Day was at the height of that in the May primary, so he delayed the date in the statute by 1 month, so our primary in COVID was in June, and then it actually automatically satisfied every voter's ability to apply for an absentee ballot to vote by mail, because he's saying you're not allowed to vote at the polls unless you have a necessary reason. So people still had the choice, but the governor was telling you to stay at home unless it was, I don't remember the term, but it was essential purposes or something, get food or get a prescription, things like that. So his authority that was passed on to election law was issued by the legislature, giving him the emergency declaration authority.
So the declaration authority, you believe, would take it out of the, as kind of thought about here, as the unauthorized change. So you're saying under a state of emergency, it then takes it from outside of an unauthorized change, because the way that this legislation is written, the authorized change would be the legislature.
Right.
So any action taken by the governor, the executive, would be an unauthorized change. However, you believe you're cloaked with the ability to do so if there is a state of emergency.
No, I'm sorry if I was confusing in my answer. It was an authorized change by the governor because the legislature had given him that authority.
Via the state of emergency.
Right.
Okay.
Right. But you have to meet criteria to issue a state of emergency.
Very, very clear, yes.
I didn't write it.
Certainly no litigation over this. Thank you.
Other questions, Mr. Kersey? Thank you, Mr. Kersey. Any member desire to call another witness, technical witness? If not, are there amendments? Gentleman from 76 seeks to amend the bill, page 2, section 45, line 39, by striking the entirety of paragraph A.
D.
No. D. Do you mind if I clarify that D? There we go. As the gentleman seeks leave to call to explain his amendment, you may proceed.
Chairman, very briefly, I think my main issue with this bill is it is a bill that will allow for lots more lawsuits, especially by people who just want to mess with people across the state without having any say whatsoever, without having any direct interest in especially a local election. And I don't think that that's right. I think this really, we heard about the potential for attorney's fees for cases. There's no reason why someone might not make this a cottage industry and just start going after people. So I think the easiest thing to do is to get rid of paragraph D, and I think that gets rid of the standing issue so that someone would have, I mean, the legislature in B and C, they can get involved, but with C, you would still have to have legal standing in order to file a lawsuit of this type. That's my amendment, Mr. Chairman.
Questions of council regarding the amendment? Questions of council regarding the amendment? Gentleman from the 100th.
Yes, sir.
Is there any section in code that would govern against frivolous lawsuits that would be put forward in the event that this paragraph remains in this bill?
I'm not sure that we have an explicit code section dealing with frivolous lawsuits. We certainly have within our procedural rules of civil procedure, rules govern against what is and is not a frivolous lawsuit. That having been said, courts tend to err on the side of caution in dismissing lawsuits based upon a charge of frivolity because of the fact that they do try to give merit and see merit in every case brought before them. They want to err on the side of caution and not deprive a litigant of a reasonable challenge. And so I think the gentleman's point is well founded that would be available to courts to dismiss lawsuits based upon a charge that they were frivolous. But I think in an instance where an election law violation has been alleged, that's a fairly serious violation. It's something that a court might want to err on the side of caution in at least hearing an initial presentation on the merits of it.
Thank you. Thank you, Mr. Chairman.
Question of council?
Amendment again, I apologize. We're
Just
proposing amendment.
striking subsection D
Okay,
on page 2, striking it entirely.
all right.
Gentleman from the 8th.
Thank you, Mr. Chair. I'd like to ask some questions of the lead sponsor of the bill, if I might,
Okay.
with regard to this amendment.
Before we do that, are there any other questions of council? If not, gentleman from the 8th seeks leave to call a witness regarding the amendment. Mr. Holstein, you are the lead sponsor of the bill. If you take the podium, you're a member of the legislature. I do not have to swear you in. Gentleman from the 8th.
Thank you, Mr. Chairman. Good afternoon. How you doing?
Well,
Good to see you. So you heard the gentleman's amendment. Can you tell me, in your words, why you believe D is important for the amendment or for the bill?
Sure. So, actually, I'm perfectly fine with the gentleman's amendment if that's
Okay.
what the committee wants to
Okay.
wants to go with. My intent with this legislation, let me go ahead and lay that out here for you guys. The intent here is to give the legislature standing to enforce and what we as a body decide to be law. Right? As you saw with in examples in previous election years, there were election officials who changed rules unilaterally, and then the legislature had no standing to bring court cases up against that, so there was really no contest to those changes. So that's what I'm trying to address here. It's not any kind of, if we need to change the language to make that intent clear, that's perfectly fine. I'm perfectly fine with the gentleman's amendment and what it seeks to do.
Thank you, Delegate.
Other questions of Delegate Holstein? Thank you, Delegate.
Yes, sir.
Thanks
Thank
for
you.
being here. All right. Is there discussion regarding the gentleman's amendment? Gentleman from the 42nd.
Thank you, Mr. Chairman. I've actually done one of these before, an election mandamus, and looking at the bill and so forth, I think it's a good amendment because the one that I did had to do with a county commission race, and the plaintiff had to actually be in the magisterial district of that particular county commissioner in order for me to proceed with the case. And I think what it would serve to do is prevent an interested group from just finding a random individual in the state to meddle in an extremely local election. I chose to litigate the case in the circuit court rather than the Supreme Court in that particular instance because it was a highly local issue. And, given the amendment, it would preserve that. And because I do think there could be some real issues if anybody in the state could challenge a county commission race in Mercer County. It could be problematic. So I would support the gentleman's amendment.
Other points of discussion? Gentleman from the 55th.
Support the amendment as well. I think it also addresses some of the concerns of the gentleman from the 5th, probably not all of them, but at least some of them. Probably helps with that. So I think the amendment's a good amendment, and I urge the committee to adopt it.
Other points of discussion? If not, all in favor of the gentleman's amendment signify by saying aye. Aye. Opposed, no. The ayes have it. The gentleman from the 76th amendment is adopted. Are there other amendments? Other amendments? If not, gentleman from the 8th to move the bill as amended.
Thank you, Mr. Chair. I move that House Bill 4205 as amended be reported to the full body with a recommendation that it do pass.
You heard the gentleman's motion. Is there discussion regarding the bill as amended? Discussion. If not, all in favor of the gentleman's motion signify by saying aye.
Aye.
Opposed, no. No. The ayes appear to have it. The ayes do have it. I declare that House Bill 4205 as amended will be reported to the floor with the recommendation that it do pass. All right, ladies and gentlemen, that's going to bring us now up to the first bill on the agenda, 4759. And I believe we have a accurate committee substitute being distributed as we speak. Committee will be at ease just 1 second. Before we go on, we have a lot of people in the room. Perfect opportunity to ask. There's a pair of glasses here. Does anyone claim them? I think they may have been here since last year. At least 50 cents. Pardon? I have one pair. That's plenty. We're going to discard these. All right, Council, you may explain the bill.
Thank you, Mr. Chairman. I'm on House Bill 4759 relating to E-Verify, the Federal Employment Authorization Program. The purpose of this bill is to verify the legal employment status of all persons who come into the employ and of an employer and to report their employment to the appropriate government agencies. The bill defines E-Verify, the electronic verification of federal employment authorization program of the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, and provides that unauthorized workers' employment is prohibited. Committee substitute amends the West Virginia Code relating to these obligations to E-Verify and what remedies are available should an employer not enroll in E-Verify and knowingly and willfully hire or continue to hire an unauthorized illegal alien as an employee. The committee substitute first amends 21(1)(b)(2) to provide definitions or updated definitions for the following terms: alien, which utilizes the United States Code, 8 U.S.C. 1101, to provide any person who is not a citizen or a national of the United States as described in that code provision. It also gives definitions related to court of competent jurisdiction as it's utilized throughout the committee substitute. Employee and employer are updated definitions. E-Verify, which is the electronic verification of federal employment authorization program, is defined. Federal Work Authorization Program is defined. Independent contractor is defined as having the same meaning as defined in 21(5)(I)(4) of this code. Most recent committee substitute also specifically references and contains 21(5)(I)(4) of this code, where we inserted language that specifically designates this particular ComSub and provides that that definition of independent contractor specifically applies to this code provision. Defines knowingly, which means with respect to conduct or to a circumstance described by a statute defining an offense that a person is aware by documentation or action that the person's conduct is of that nature or that the circumstance exists. It defines lawful presence or lawfully present, which is, again, a term that is utilized throughout the United States Code, but it means a person shall be regarded as an alien, unlawfully present in the United States only if the person's unlawful immigration status has been verified by Immigration and Customs Enforcement, ICE, or any successor agency thereto under 8 United States Code 1373C. No officer of this state or any political subdivision of this state shall attempt to independently make a final determination of an alien's immigration status. However, an alien possessing self-identification in any of the following forms is entitled to the presumption that he or she is an alien lawfully present in the United States, and that would be a valid, unexpired West Virginia driver's license, a valid, unexpired West Virginia non-driver identification card, a valid tribal enforcement card or other form of tribal identification bearing a photograph or other biometric identifier, any valid United States federal or state government issued identification document bearing a photograph or other biometric identifier if issued by an entity that requires proof of lawful presence in the United States before issuance, a foreign passport with an unexpired United States visa and a corresponding stamp or notation by the United States Department of Homeland Security indicating the bearer's admission to the United States, and 6, a foreign passport issued by a visa waiver program designated country with the corresponding entry stamp and unexpired duration of stay annotation, or an I-94W form by the United States Department of Homeland Security indicating the bearer's admission to the United States. The committee substitute also provides an updated definition for license, what constitutes a private employer, what constitutes a public employer, what are records that may be required by the Commissioner of the Division of Labor or the Attorney General for the purpose of enforcing the provisions of this article, definition of an unauthorized worker, which is a person who does not have the legal right to be employed or is employed in violation of law, or an alien who is not authorized to work in the United States as defined in 8 United States Code 1324 AH3. It also defines, lastly, the term willfully, which is conduct that is intentionally engaged, and the consequences of such conduct results in a violation of this article. Now, moving to 21(1)(b)(3). This committee substitute amends that section to provide that no employer may knowingly and willfully hire or continue to employ an unauthorized alien to work. It also requires every employer in West Virginia to enroll in E-Verify. Now, E-Verify is an employment verification web-based service. It's free. It provides an electronic verification of employment eligibility for newly hired employees and for existing employees. An employer creates an account for his employees, and once you do it for one, you have to do it for all of your employees. You have a memorandum of understanding with the E-Verify once you set up an account, and you are required to agree to the memorandum of understanding and to save that memorandum of understanding. And right now, we're all utilizing what is called an I-9 form, and that's an employment verification form that Immigration and Naturalization uses currently. And you take the information from that I-9 form and you enter it into the E-Verify system for your employee, and you can only do that after the employee has accepted employment. It cannot be used as a pre-screen. You cannot screen employees with the E-Verify system. Once you enter in all the information that is required in I-9, then you get a result back, usually instantaneous, within a few seconds, stating whether the person is eligible to be employed or whether they are not eligible to be employed. There is a sort of in-between where they may need more information, or they don't have a record which is sufficient to give you a final answer. And in that instance, I believe you have 10 days by which to address that eligibility for employment. Not trying to get into the weeds too much, but depending upon which documents you provide, you would have to go to either the Social Security Administration, or you would have to go to the Homeland Security to get further information to help clear up any of those in between where they may need more information to verify your employment status. That's E-Verify in a nutshell. So going back to 21(1)(b)(3), this section that requires every employer in West Virginia to enroll in E-Verify. It also requires employers to verify the employment eligibility of new hires within 3 days after the employee's first day of work for pay, unless the employee will work for less than 3 days. And if that is the case, then the verification must occur on day 1. 21(1)(b)(3) does have exceptions. The requirement to E-Verify does not apply to the following: a relationship between a party and independent contractor, or the employees of an independent contractor performing work for the party. A casual domestic labor situation which was performed within a household, and when individual homeowners who hire workers on private property used exclusively for the owner and the owner's guests. 21(1)(b)(4) is not amended by this committee substitute. We move on to 21(1)(b)(5), and that is amended to address penalties, the suspension and revocation of licenses, determination of how employment status is to be determined, and allows for a writ of mandamus if a government entity does not enforce the provisions of this article. Subsection A of that section states that upon a knowing and willful first violation of 21(1)(b)(3) of this code by an employer, the Commissioner of the Division of Labor may, after providing notice and opportunity to be heard pursuant to the Administrative Procedures Act, suspend the business license of the employer for up to 10 days, or until compliance is accomplished, whichever is later. If the employer is a contractor or subcontractor under a contract with the state or any political subdivision The Commissioner may, within the same administrative proceeding, also suspend the applicable contract for any time that the employer's licenses are suspended. However, if the employer accomplishes compliance with this article prior to the start or prior to the completion of any administrative action, the licenses shall not be suspended. Proof of compliance includes submission of a signed, sworn affidavit stating that the employer is in compliance with all provisions, and a copy of the memorandum of understanding issued to the employer by virtue of enrollment in E-Verify. In instances where the employer is a contractor or subcontractor whose contract has also been suspended, if the contracting parties are willing to resume the contract, upon the reinstatement of the license, the contract shall also be reinstated. Subsection B deals with a knowing and willful second violation. A lot of the same provisions of subsection A apply to subsection B. Major difference being that the suspension of the licenses can be for a period of up to 60 days, whereas the first violation is 10 days. There is a temporal component by which a second offense can be filed against an employer, 10 years. An adjudicated first violation of this section by a private employer, as demonstrated by a final order not subject to further appellate processes, must have occurred within 10 years immediately preceding the date of application by the state entity, political subdivision thereof, or state to the Commissioner in the current proceeding, in order for a second offense to be brought against a private employer. The same administrative protections apply here as they did in A about compliance. So the compliance requirements and what an employer can do to demonstrate compliance, provisions relating to contracts and things like that, those two apply in Section B as they did in Section A. The only difference really being that it's a 60-day potentiality versus a 10-day potentiality, which is in A. Turning to subsection C, upon a knowing and willful third violation by an employer, the Commissioner of Labor may bring a civil action in a court of competent jurisdiction. Now, trying to find my concept here. A court of competent jurisdiction is contained within our definition section, and it is a circuit court where the violations of 21(1)(b)(3) of this code is alleged to have occurred. So moving back to subsection C, the Commissioner may bring a civil action in a court of competent jurisdiction to permanently revoke the business licenses of the employer, and the court shall permanently suspend the license of the employer upon making specific findings that the employer knowingly and willfully violated the provisions of this article, and then that court shall order that any applicable governing body will permanently suspend the employer's licenses. Again, there is a temporal requirement. It's another 10 years. An adjudicated second violation of this section by a private employer, as demonstrated by a final order not subject to any further appellate processes, must have occurred within 10 years immediately preceding the date of application by the Commissioner, in order for a third offense violation to be alleged against the private employer. And not to belabor that point, but what that basically means is that if you're charged with a first offense and it is finally adjudicated and it cannot be appealed any further, and 11 years goes by before a second offense would be leveled against you, they could not, under this bill, charge you with a second offense in that instance, because a time of greater than 10 years would have elapsed. If that second violation occurred 9 years, then that would attach and there would be a second offense violation. The same thing applies with the third violation. The temporal requirement of 10 years there applies as well. If you've been through two violations, you've been adjudicated, and then things go pretty well for 15 years, and you get a third violation alleged against you, that 15-year period is going to keep you from being subject to permanent suspension or revocation. So we wanted some time requirement there, and the way the ComSub reads is that it is 10 years as it reads in this committee substitute for both second and third violation. The committee substitute then amends 21(1)(b)(5)(e) to establish that the determination of whether an employee is an unauthorized alien is to be made by the federal government. The Immigration and Customs Enforcement, or any successor agency thereto, should their role change or someone else's role expand into that arena, under 8 U.S.C. 1373. The court shall only consider the federal government's determination, and that's it, when deciding whether an employee is an unauthorized alien, and may take judicial notice of this verification or request of the federal government automated or testimonial verification relating to the status of the alien. Basically what that means is a court can't go on its own fact-finding mission. It cannot take up independent action to determine eligibility or whether someone is of an appropriate status in the United States. This establishes that only the Immigration and Customs Enforcement individuals will be able to make that determination. 21(1)(b)(5)(f) of this committee substitute provides that if any agency of the state or any political subdivision does not enforce the provisions of this section, then the Attorney General may compel enforcement of this section by a writ of mandamus brought by the Attorney General in the circuit court for the county where the agency of the state or any political subdivision thereof is located, or in the Supreme Court of Appeals. The reason we have in circuit court or in the Supreme Court of Appeals is because that's what our Constitution, the West Virginia Constitution, provides. West Virginia Constitution provides that mandamus lies in circuit courts, but mandamus also lies in the Supreme Court. There's some questions as to which court would be appropriate for a writ of mandamus. And a writ of mandamus, in a nutshell, is a writ. It's an extraordinary writ, and it is a writ that you file in a court of competent jurisdiction where you are compelling a public official to fulfill their duty. There is a duty in the code that is imposed upon that public official. They refuse to do that duty. You can then file a writ of mandamus where a court can compel that public official to fulfill their requirements and their duties that are contained within the code. I wanted to say that so there's maybe a general understanding of what exactly a writ of mandamus is. So in this instance, if a political subdivision or an agency of the state refused, then the Attorney General could file that particular writ of mandamus in circuit court or the Supreme Court of Appeals. Now, not to get in the weeds too much, but the difference between filing a mandamus in the Supreme Court of Appeals versus filing a mandamus in circuit court usually relates to the record that was developed underneath. If there was a complete development of the record underneath, in this instance, it would go to the Supreme Court of Appeals, and if there was not a record that was completed underneath the writ, then you would go through the circuit court for the development of a record. (21)(1)(b)(6) is repealed in this committee substitute. (21)(1)(b)(6) deals with 21(1)(b)(6) deals with deductions, deductible business expenses as it exists in the West Virginia Code, and it is being repealed in this, so it would no longer be applicable, the denial of deductible business expense. 21(1)(b)(7) is amended and provides in subsection A that a contractor of any tier is not liable when its direct subcontractor violates this article, so long as the subcontractor is an independent contractor. Subsection B is amended to provide that an employer or subcontractor that establishes it has complied in good faith with 21(1)(b)(3 has an affirmative defense that the employer did not knowingly and willfully hire or employ an unauthorized alien. Subsection C is amended to provide that an employer that terminates an employee to comply with 21(1)(b)(3 will not be liable for any wrongful termination claims made by a terminated employee. Subsection D is amended to provide that entrapment is an affirmative defense to a violation 21(1)(b)(3. However, to claim that defense, that affirmative defense of entrapment, the employer must admit by testimony or other evidence the elements of the violation. An employer, who asserts an entrapment defense has the burden of proof, and they have a burden of proving beyond a preponderance of the evidence as outlined in this committee's substitute the following. A, the idea of committing the violation started with law enforcement officers or their agents rather than with the employer. B, the law enforcement officers or their agents urged and induced the employer to commit the violation. And C, the employer was not already predisposed to commit the violation before the law enforcement officers or their agents urged and induced the employer to commit the violation. Subsection E is amended to provide that an employer is not in violation of 21(1)(b)(3 of the Code during a time period where the E-Verify program would be suspended or not operational, or if the employer acts upon false results generated by the E-Verify program concerning an employee's work authorization status. 21(1)(b)(8 is amended and states that by July 1st of this year, the Commissioner of the Division of Labor shall propose rules for legislative approval to implement the requirements and provisions of this section. Mr. Chairman, that is the committee substitute.
Thank you, Council. Before we go to questions of Council, I failed to mention at the beginning of this meeting, although I did mention it on the floor today, that we are not going to run 4654 today. That's the bill dealing with exemptions on criminal penalties on the display of obscene material to minors. So if anyone's here, I don't want you to have to listen to all this if you're not of interest. So, having said that, are there questions of Council on 4759? Questions of Council. Gentleman from the 20th.
Excuse me. The last statement you said there was about the rules, and they need to be proposed in July of this year.
That is correct, sir.
What's the effective date of this bill for E-Verify effectively? It's January 1st, 2025?
I'm sorry, I didn't. What was the question? I'm sorry. I was.
Is the effective date January 1st, 2025 for the E-Verification? Page 5, sub B.
I just want to verify that I'm not giving you a wrong date. Yes, effective date is January 1, 2025, with a rulemaking provision of July 1, 2024.
And my question there is, well, the rules won't be complete before the effective date, would they?
That would be correct.
Okay. Another
They
question.
would be submitted to legislative approval, but they would not be completed through the legislative rulemaking process.
Action would not have been completed and taken on them yet.
Correct.
But they would be completed by July 1st of 2025, correct?
They would be, yes.
Okay. Another question is, when going through and explaining what an employee is, how is it handled through third-party staffing agency? Who would be required to do the E-Verification in a third-party staffing agency?
Could you give me a hypothetical?
For example, somebody goes to hire an employee through a staffing agency, and what happens there is the employer pays, let's say, $21 an hour, and the staffing agency takes $3 of that in order to do bring the employee on board, do their I-9, run through that process. But then who actually does the electronic verification?
If you're having staffing do the electronic verification, I believe the burden under this would fall on them to be conducting the E-Verify process under the hypothetical you just gave.
And how would they do that, since they never employ the individual?
Just reviewing real quick. I think under 21-1B3, there would be a requirement that it be a knowing violation. In that situation, if it was not a knowing violation, and if you are using a staffing company that does that sort of E-Verify for you on a contractual basis, then I don't think that they could allege that you knowingly and willfully violated the provisions of this section.
But by definition, but in the E-Verify process, on, like, in this booklet, it says that you can't start before employment. You can't start an E-Verification process of an individual before employing them. How would they do it if they're never employing them? I mean, basically, it would come to the point, if you hire through a third-party staffing service, it would be a violation of the E-Verify article, correct?
If you hire through a third-party staffing, would it be an E-Verify violation in what instance?
In the instance that you let the third-party staffing service do the E-Verification for you. Because currently, they do all the I-9 information.
Let me interject here and ask a question of the gentleman from the 20th. If you're hiring a staffing agency, the staffing agency employs the individuals, and the one who brings the, let's say, a temp in, a temporary worker, then I'm just contracting with the staffing agency. I'm contracting for that person to come and do contract work for me, but they're employed by the staffing agency, not me. So that's their employee. They would have to do their own E-Verification under this scenario, not me, because all I'm doing is contracting. So that person will be an independent contractor, as far as I'm concerned, not my employee. Is that the situation you're talking about?
Yes, that's the situation I'm talking about. I'm just concerned of, are they an employee of the staffing service, or are they an employee of the one that's actually
They would be an employee of the
employer.
staffing service, and the staffing service would have to then E-Verify their own employees. So if that offers any clarification.
All right.
And the gentleman may proceed.
Another question I have is on the definition of employer. So if you look at seeks to employ an individual or individuals and that is registered or registered with the Secretary of State.
Yes. That is registered or registers with the Secretary of State. Okay.
And my question there is, if somebody comes in from a state that does not have E-Verify and is here for less than 30 days and comes into the state here less than 30 days, do they have to E-Verify?
They would not, under the way the West Virginia Code is currently structured.
And that's where my question lies. Are we putting burdens, basically putting a system that state basically, businesses in this state have to go through where they could possibly be competing with somebody out of Kentucky or Ohio that does not have to go through this verification process.
So we have a blanket prohibition of maintaining employment for someone, but the problem is the language that you stated, which is registered or registers with the Secretary of State. We have a specific code, 31D 15-1501, which deals with the authority to transact business and jurisdiction over foreign corporations. In the hypothetical you've given, where it is less than 30 days, and would it be? And if I'm assuming in your hypothetical, it is not a repeating obligation of this company through this contract. Is that a fair assumption of your hypothetical?
Yes, it's a one-time bid.
If it's a one-time bid of less than 30 days, then there would not be a need to register under West Virginia Code as it currently stands. If there's no need to register with the Secretary of State, then they would fall outside the definition of employer under this committee substitute.
And in that definition of employer, it's fewer than 15 people?
That is correct. The employers who employ fewer than 15 people are not employers for purposes of this article for small businesses.
And that's where my next question comes in. If we're limited to 15 people for the definition of employer, on page 5, subsection A, we say no employer may knowingly or willfully employ, hire for employment, or continue to employ an unauthorized alien to perform work within the state of West Virginia. So that's no employer except for those with 14 or less employees. So you can do that as long as you have 14 or less employees.
Under the way the ComSub is drafted, that would be right, sir. That is correct.
Okay. And in prior law, that was not the case. And one other question, I just want to get kind of at what is a violation of the E-Verify statute. So it's not hiring an illegal immigrant, is it? Or the E-Verify federal law?
I'm sorry.
For example, let's say I signed up to do E-Verify.
Okay.
Had an ID, signed up, had a memorandum of understanding with the federal government saying I was going to do E-Verify, and I was on vacation, but hired somebody while I was gone, and when I got back from vacation, I went ahead and ran them through the E-Verify system, but they'd been working for me for 4 days. Would that be a violation of the E-Verify statute?
Under West Virginia law, in this committee substitute, on day 4, that would be a violation of this section. Shall verify the employment eligibility of new hires through E-Verify within 3 days after the employee's first day of work. So I guess after the first day of work, in that instance, 4 days would be okay because it would be within 3 days
Well, let's say 5
after the
then.
first day. Okay, 5 would be outside of the provisions of this committee substitute and would be considered a violation if it was knowing and willfully.
And what if let's say another one, for example, I got a TNC, temporary non-compliance, and I refused to hire that person and hired somebody else instead. And would that be a violation of E-Verify law, the federal law?
I think the federal law, there has to be an opportunity for them to be able to address that intermediate section where you're not approved and you're not disapproved, but they need more information. I think there is in federal law, there is a requirement, and I think it's a 10-day requirement that they be able to go if they want. And I think that actually rests with the employee, because some employees may walk away at that point, but if they choose, then they have 10 days by which to either go to the Social Security Administration or to the Department of Homeland Security to have a meeting and provide further information to give clarification on their employee authorization status.
But I would be in violation of a standpoint of, basically, I would be discriminating against them if I hired somebody else and refused to hire them once they got that cleared up after the 10 days.
Are you asking in this committee substitute, or are you asking in federal law?
Federal law. Because in the federal E-Verify, it says you shall not discriminate based on a temporary non-compliance.
I will admit that I am not as well versed in the federal law as I am obviously this committee substitute on the requirements. I know we have some technical experts in the room that probably would be better posited to answer that particular question as it relates to E-Verify and discrimination claims of a federal nature.
Okay, and then in the committee substitute, one other question I have is on the notification of the public. How will businesses know right now in the committee substitute what, that this is becoming law? Like, how will they know they have to do the E-Verify? What's the notice provisions provided?
I don't think there are any specific notice provisions in terms of, are you asking?
Who's telling the businesses of this state that they have to E-Verify every employee that they bring on board?
Well, I think that one can make the argument that under rulemaking authority, that the Division of Labor would be responsible for implementing the requirements and provisions of this section. I think part of that would also be educating the employers of West Virginia that they are now in an E-Verify mandated state.
And they'll be posting on their website, correct?
Yes, it says in subsection A of 21(1)(b)(8) that posting educational information and materials about the E-Verify program on the Division of Labor's website.
And that would be something that would be, but there's no specific notification to each employer?
There is no specific notification period within this committee substitute. However, there is built into the rulemaking provisions of 21(8)(b)(8) that type of information would be posted on their website.
All right, thank you.
Yes, sir.
Other questions of council? Gentleman from the 65th.
Thank you, Mr. Chairman. Council, I have a couple questions. So, for the 15 employee threshold, is that employees who are, so 15 employees at one time? So, for example, if I own a small restaurant, typically in a restaurant industry, turnover is kind of high. So if I hire 30 people in a year, but at no point in that time do I have more than 14 people working for me, how is that looked at?
I don't think the cumulative impact of hiring 30 employees would matter in that instance. As per the comp sub, it would be whether or not you had 15 or higher at any point in time, which would raise you above that exception amount of 15 employees.
Okay, so even though I've hired 30 people throughout the year, and as long as I don't have more than 15 at the time?
That's correct.
At any point in time. Okay, thank you for that. I also believe that you had mentioned that political subdivisions have to enforce this. Is that correct?
Yes, I'm sorry. I'm just getting to the provision
no worries.
so I can refer you to it.
Thank you.
That is 21(1)(b)(5) subsection F, which relates to, I think, the question you're asking.
What page is that?
That's page 9, starting on line 74.
Okay, so that process would be that the state would inform the political subdivision of a violation, and then the political subdivision would have to revoke a license?
If there's been an Administrative Procedures Act implementation by the Commissioner of Labor on a first or second violation, or if a court of competent jurisdiction in a third violation enters an order suspending the license or licenses of a private employer, and then, for instance, if the city of Parkersburg requires its own license in order to do work, and they say, no, we're not enforcing that,
Sure.
then the Attorney General can enforce that, and that violation, and through a writ of mandamus compelling the representative in that hypothetical, the city of Parkersburg, to suspend that license.
Great. Thank you very much for that.
Yes, sir.
And then the one last question I have is, so when an employer does the E-Verify, how is the state informed of the E-Verify? How does that work?
You mean at the moment of hiring?
Yeah, so, because like the E-Verify, it sends to the federal government, right? But how does the state of West Virginia know? What is that process?
There is no affirmative duty to notify the state of compliance with E-Verify. You are required under E-Verify to maintain documentation and proof of compliance, and I believe that's part of the memorandum of understanding that you also get with the E-Verify system when you sign up and create an account. The state of West Virginia would find out when there would be a complaint or some sort of action brought by the Division of Labor because of information that's been brought to their attention. And then at that point, you would have the record.
Who brings that information?
I'm sorry?
Who brings that information to the Division of Labor? Is it just a customer or?
Could be.
A whistleblower in the company or something like that? I mean, does the federal government at all inform the Division of Labor ever?
I'm not aware of that. I want to say it would probably come mostly from third-party complaints.
Okay, great. Thank you. Thank you, counsel. Thank you, Mr. Chairman.
Other questions of council? Gentleman from the 44th.
Thank you, Mr. Chair. Council, earlier there was some back and forth about whether or not businesses that were conducting business activity in West Virginia would be covered under this statute or this bill as proposed. If we were to amend it to capture businesses that engage in business in this state, other than businesses primarily engaged in trucking, shipping, and rail transportation, based on your review of the law, do you think that would run afoul of the interstate commerce clause?
Yeah, and I know we discussed this earlier. I think if there was an amendment to that effect, I think we would have to tread carefully with the Commerce Clause. But anyone that is actually doing business within the state of West Virginia, are you speaking of the general prohibition of a violation, or are you speaking of the licensure suspension?
I'm specifically talking about the definition part of employer, as opposed to having it defined as someone or a business that's registered or will register with the Secretary of State. If amended, it would be defined as someone, a business primarily engaged in trucking, shipping, and rail transportation. A business that engages in business in this state other than businesses primarily engaged in trucking, shipping, and rail transportation.
I think where you're going with this, Delegate, starts to answer the question of not violating the Interstate Commerce Clause. The only thing I could see where it might need more fine-tuning would be that sometimes there are intrastate rail lines and rail activities. There are intrastate trucking that are conducting licensures and maintain trucking routes and trucking business practices that are completely within the state of West Virginia. I come from southern West Virginia. There's a lot of interstate trucking with in the coal industry, and so I think there can be some fine-tuning in that regard, but I do think that you are getting in the right direction of establishing some way where you're not violating the Interstate Commerce Clause.
Very well. So you could include interstate as a qualifier before trucking, shipping, and rail transportation and still capture the intrastate businesses that would be otherwise applicable under this bill.
Yes, I think you're right, sir.
I appreciate you.
Other questions of council? Gentleman from the 76th.
Thank you, Mr. Chairman. Council, Couple different things. Number one, is someone who has been granted political asylum, are they eligible to work under federal law?
I want to say that that would probably be case dependent.
Well, okay, and I apologize, I think I misspoke. Someone who's applied for political asylum, not someone who's been granted it, but who's waiting.
I still think that in that, and actually I was answering that question in my head when you asked it, but I would think that that would be case dependent, depending upon their circumstances and where they stand in the process. I believe when you come to the United States and you enter into our country and you apply for asylum, you're given a court date to which there's an aspiration at least that the person will actually appear. But I'm not sure that you automatically gain this ability to lawfully work in the United States at that point in time.
Very good. And this next question, and that one might be better for someone else in this room with expertise, but the E-Verify program, do you know whether it updates information, how quickly it updates that information? Because I'm assuming that someone's immigration status can change. It does change, and so how long does it take for that to be updated? And again, if you don't know, I'm happy to call someone else up later.
I don't know how often. I do know that the whole system is built upon databases that are updated. The frequency of that would probably best be answered by an expert, which we have in this room.
Okay. Second thing, in the penalty section, they state, I think under at least A and B, if the employer accomplishes compliance with the article prior to the start or prior to completion of any administrative action, the business license is not suspended. Does that mean that somebody can comply and that there won't be any penalty associated with that?
Where are we at? I'm sorry.
I'm sorry. No, I'm going quick. It's in subparagraph, let's see.
If you just want
it's 21-1B-5, page 7 of the committee substitute, A, line 27.
Okay.
Starting with if.
I'm sorry, I just wanted to follow along.
Yeah.
What was your question, sir?
So it talks about if an employer accomplishes compliance prior to the start or completion of an administrative action, that they will not be suspended.
That's correct. That's
okay.
What the substitute says.
Does that also mean, though, like, for example, if someone complies even having violated the law, and let's say it happens again, would they be on their second violation that second time, or does that actually prevent them from fulfilling the administrative penalty in Section 8? Section A, I'm sorry.
I read the proviso, which I think this answers your question, as a completed, adjudicated first violation.
Okay.
If there is a situation where they demonstrate compliance prior to what would be considered an adjudication, then they would not be subjected to second offense violations under the way this committee substitute is drafted.
Okay. And then my last question, on page 9, subdivision F, it talks about the Attorney General being able to bring a writ of mandamus.
Yes, sir.
Is there an inherent conflict because of the fact that the Attorney General also represents agencies such as the Commissioner of the Division of Labor?
I don't think there is. The Attorney General will oftentimes have embedded Attorney Generals across various agencies, and I don't think, as long as they're walled off from each other, I don't think there's a conflict in that sense.
Okay. Thank you. Thank you, Mr. Chairman.
Other questions of council? Question of council, does any member seek leave to call a technical witness regarding this bill? I have some questions. Gentleman from the 68th, who would you like to call? Gentleman from Numbers USA, thank you for being here. If you would take the microphone over there. If you would introduce yourself, and then I will swear you in.
Yes, sir. Andrew Good, Numbers USA. I'm the Director of State Government Relations.
Very well. Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Gentleman may proceed.
Thank you, Mr. Chairman. You've heard some of the concerns expressed here at length. Could you address the questions that have been raised by the members?
Sure. I can give some information, some context about the use of E-Verify in some states already mandatory in certain instances, but also voluntarily across the nation. In fiscal year 2022, that's the most recent year where there's data available, there were 47 million, more than 47 million uses of the system of E-Verify for new hires across the nation. Of those, 98.31% were confirmed instantly, within seconds while you're sitting there. The rest get a tentative non-confirmation. Most of the tentative non-confirmations are ultimately uncontested because the person is not legally authorized to work in the United States, but the ones that are contested, E-Verify guides you through the process to, as I think was spoken here earlier, to either Social Security Administration or DHS to kind of resolve any issue that they might have. Sometimes there's typos, sometimes there's just a problem with their records, and it's something that you probably would want to get fixed anyway.
All right, thank you. In other states that this is mandatory, have we had major issues with incorrect records?
No, sir.
Thank you. And in the question of the staffing agency that was raised earlier, the staffing agency would in fact be the employer and would be who was required to complete the E-Verify check?
Yes, sir.
And what further information other than what's required by an I-9 now would be required for employers under E-Verify? What information beyond what's currently required for employers to gather for I-9 verification?
None. It's just taking the I-9 and verifying that the information is true and legitimate.
All right, thank you.
I can also speak to the parole question that was asked by the gentleman from the 68th.
Does the gentleman from the 68th have any further questions?
No, not at the moment.
Gentleman from the 76 may inquire.
Sure. If you'd like to respond to what I asked earlier, I'd appreciate that.
Sure. There's been some differences when it comes to asylum and how different administrations are adjudicating those cases. And ultimately, it won't affect anything related to E-Verify because you're asking the federal government what they've already determined to do, whether they've given an employment authorization document or not. And so, but their records are instant. If they have, it's already there. So there should not be a big E-Verify problem regardless of how they decide to handle asylum processing, which, of course, like I said, has changed.
And how long does it take normally to upload? I mean, if there's a court case where a judge makes a determination that someone is eligible to work?
So it's generally, right now, I can speak to, right now, it's generally not going through the court case process. They already have employment authorization documents. Whether or not that's how it's supposed to work is kind of not in this purview here, but that's how it's currently working. So the EADs are coming first before court records are really what's triggering it, if that makes sense.
Yeah, I guess I'm trying to understand then. So it sounds like the authorizations are coming through, I guess, but the authorizations have to come from a government agency, right? Not necessarily a court system. So I'm trying to think about how long is the delay between when an authorization might have occurred and when that will be uploaded to E-Verify for an employer?
I couldn't give you an exact time, but I'm trying to tell you that most cases are being administratively adjudicated before there's a court proceeding, if that makes sense.
No, I understand what you're saying. I'm trying to think about a scenario where individual A understands that there's been an adjudication at the administrative level, goes and applies for a job, let's say the next day, employer uses E-Verify,
will that pick that up that next day, or is there potentially some problem that will create an administrative quagmire for the employer?
So I think the answer to that is that in that scenario, it might trigger a tentative non-confirmation, but with the proof that the case and the benefit had been adjudicated, that would be something that the employee could go in that window of time, that 10-day window, and get it fixed with Department of Homeland Security so that they would be able to fully complete their E-Verify case.
Okay. Thank you, sir. Thank you, Mr. Chairman.
Thank you. Other questions, Mr. Good? Gentleman from the 20th.
Thank you. And you said you were with Numbers USA?
Yes, sir.
So are you a registered user, or have you done this E-Verify process?
Yes, sir. Actually, as an organization, we've done it, I think, since 2005, and you can also self-verify. I've verified myself. You can, not through an employer, you can go onto E-Verify and check your own status. It also allows you to lock your Social Security number, so it's not allowed to be used in employment, like identity theft for employment. So I've done both of those. I can speak to some of the tentative non-confirmations we've gotten as an organization over the years, if you'd like.
Well, and that's what my question comes from there, too. And I wouldn't ask you to speak to tentative non-confirmations because I understand you're not allowed to speak about specific individuals in those, in the E-Verify law. But my question is, you do it, so when you do E-Verify, you're allowed to do it now? You're not in West Virginia, correct?
I'm in Virginia, so no.
So the company's out of Virginia?
Yes, sir.
So are you required to do E-Verify in Virginia?
We are not, but we signed up as early as we could because of our nature in involvement in the issue.
So any company in West Virginia could do it. I mean, my company does. We verify all of our employees. So any company could do it right now if they wanted to.
It is available nationwide. That's correct, sir.
But it's not required in your home state. For what reason?
I think you have to ask the elected officials who are making those decisions.
Well, and the question is, do you have more than 50 employees in Numbers USA?
We do not.
Because 50 employees is the requirement in Virginia when contracting. So because you're not over 50 employees, you don't have to.
Also, we don't contract with the state, so it wouldn't apply to us anyway. But
okay.
Yes, sir.
And is there, this is the booklet on the E-Verify. I mean, I understand it said it's an easy process and everything, but going through this, would that be something that, when your license is at stake, is that something that you think most people would just hire it out to a third party to be able to do their E-Verify?
I don't have statistics on how many entities that currently use, because there's a million businesses that, about a million that use E-Verify already nationwide. I would say definitely the vast majority do not use a third party to do so, but I don't have exact statistics on that.
And on these situations, whenever you violate E-Verify, and I went through a few scenarios earlier, and I just, like, for example, if you and I were both registered users, you were out of town, or let's say we weren't both registered users and we were running a company together, and I decided, well, while he's out of town, I'll go ahead and log on and verify someone on your account. Would that violate E-Verify statute?
So the E-Verify system allows you to have, you must have at least one administrator, but you can have more than one administrator. So I'm actually glad we came back to this question, because if one of you is out of town and the other person has the power to hire someone, they may also be an administrator who's listed on the account, and would make sense probably for them to be so.
But if I wasn't aware of that and I used your account, would that be a violation of the E-Verify law?
I actually don't know. I can get back to you on that. I don't think so, but because the idea is for the company to use it for verifying all new hires. Now you want one of the administrators to use it, so I'm not sure who would be responsible or not.
In the manual, it says you shall not share IDs or password. So, and that just goes to my point that you're here to talk about this legislation. We're expecting every single employer in West Virginia to know this. And if you're not aware of it, this is a violation that would constitute losing your license under the current comp sub, is it not? If you're not abiding by the laws in E-Verify?
Well, I think that the goal of E-Verify is and always has been that you want to give a safe harbor for employers who are trying to do the right thing in their hiring and also not facilitate the ability of employers who are bad actors to hire illegally.
And that's one of my questions. Like originally, the bill, I definitely appreciate the comp sub because the original bill didn't have knowingly and willfully in it. It just, I mean, if somebody did this unknowingly, unwillfully, then they would be in violation of the E-Verify statute. But one of the questions I have is this bill, you have to do it within 3 days.
Right.
So in this administrative process where somebody's license is at stake, let's say the Department of Labor has determined someone's license is at stake, they've been reported for one reason or another, let's say their competitor decided to stick it to them, I mean and called the Department of Labor and said they're not E-Verified, and they go in and determine that they haven't signed up for E-Verification, how would they remedy that?
So first, let me make sure I've got the scenario correct. You're talking about a valid complaint from a private citizen, which means that they have to have some kind of knowledge that is not a discriminatory or too vague to act on in order to even trigger that process, right?
Let's say that the Department of Labor is there at the office because of a complaint.
Because of their random audit process, maybe.
Either random audit or a complaint from an individual, one or the other.
And so you're talking about a first-time violation?
First-time violation.
And my understanding is that you, I think, and actually I could use a copy of the committee substitute, but my understanding of that is that you may have it suspended until you can remedy the fact that you're not signed up for E-Verify, which is, I think, the point of the legislation altogether, right?
And that's where, how would you remedy it if if E-Verify says and the law says you have to do it in 3 days? Let's say that the violation, let's say you haven't been E-Verified, the employer hadn't been E-Verified for 3 months. They hired someone 3 months ago. How do they rectify the situation if they have to E-Verify everyone within 3 days and when the hiring took place 3 months ago?
Well, and perhaps if you are audited and you're using E-Verify, you're going to have a record of the fact that that your cases for all those employees are in the file. So are you?
Well, I'm assuming they didn't sign up or have an MOU for the E-Verify.
So they didn't sign up for E-Verify?
They didn't sign up for E-Verify.
Okay.
They said, I didn't get any notification, didn't know. I hired employees 3 months ago. How do they rectify the situation?
You would take 20 minutes to sign up for E-Verify, get that MOU, and then I guess have a signed sworn affidavit to that effect that you produce to the state agency.
But you're still in violation. That's why I don't understand.
But the bill says that at that point you have overcome the violation.
Well, you're still not in compliance with the federal E-Verify law because at that you still have not verified within 3 days of employing the individual. Plus, if you receive, let's say you receive the MOU on July, the federal E-Verify law says that you can't go back and E-Verify somebody that was hired on before the MOU. So what I'm saying is it's impossible to get into compliance with E-Verify at that point.
No, I don't. I certainly don't think that is how the statute is enforced federally.
If the federal law says you cannot E-Verify somebody that was hired before the MOU was created.
Well, I think there's a whole bunch of other things that I don't know if you want to talk about them or not, but there is a system that you could use instead of E-Verify called Image that requires you to requires you to verify every employee ever, every employee that you currently have, and it's a further document check. It's a much more extensive system than E-Verify. So image is, and I don't think you're talking about that, but that's...
No, I'm not.
Okay, then I don't think that applies.
Mr. Chairman, I'm the CEO of Numbers USA. Could I also answer this question?
We'll call you in just a second. Just stay right there and let this gentleman complete his questions, and then call another witness.
Yes, sir. Sorry, I want to answer your question about the differences between E-Verify and other systems.
No, I'm specifically just talking about E-Verify, not the others.
Right, because we're only talking about new hires.
Yes, that's correct.
Okay.
But if you had hired them 3 months ago is what I'm referring to, before you signed the MOU, because you didn't sign up for the MOU at the time of hiring these individuals, even though it was past the date of the legislation requiring.
Okay.
But one of the questions that I have, and this is just about E-Verify in general. So there was an audit done of the E-Verify system. And I'm just trying to see how this happens. So according to an audit the federal government conducted by WeStat, 54% of undocumented immigrant workers are approved to work by the E-Verify system. How can 54%?
Was that the 2007 WestStat report or the 2012 WestStat report?
I don't know which, it doesn't have a date on it.
Those are outdated, fully outdated. You've had multiple administrations. They've added photo matching tools. The E-Verify system is much, much more secure in terms of identifying document or identity theft. It's not perfect at identifying document or identity theft. That's because it's supposed to be pretty gentle, because you definitely don't want to have an American worker who doesn't pass E-Verify for whatever reason and can't get it resolved. So basically, those reports were before the system became much more secure. There's no perfect system in a world of identity theft, so it's possible that you could game it, but it's much less than 54%, and those reports are totally outdated.
Okay, so how did it become much more secure?
With things like the photo matching tool and basically additional information that has come into the databases that are being queried by the system.
A photo matching tool, and that's where I'm concerned about too, because most I-9 verifications that you would submit don't have a photo identification on them.
That's right. I mean, but if you, like for instance, if you produce your passport, which is a single document, it shows that you're both an American and legally present, so you're work authorized and legally present. Like, now they can see your passport photo because the federal government already has your passport photo. They're the ones who gave you the passport. So now the passport photo, for instance, shows up, and lots of people have passports. A lot more people than did in, say, 10, 15, 20 years ago. So these are the kinds of things that just kind of naturally make the system more secure, in addition to technological changes that they've made behind the scenes to improve the system and its reliability.
Now, who's responsible for identifying that? And that person sitting in front of them matches that photo?
Is
it the employer?
I mean, if they're getting a confirmation, then you're good to go. But yeah, if you want to compare the photo and make sure it's the person sitting in front of you, then you don't have to, though, because you've already got a confirmation. I'm just saying it's an additional resource that the system is just kind of pulling together for everyone involved.
And that's what I'm asking is, and though the number may not be 54%, there is a number that gets through because you're identifying the document, not the individual, through the E-Verify system.
That's right. If someone had completely stolen a person's identity, someone without a passport, someone who isn't in the driver's license database, whatever, then it's possible to game the system. That's true. But that's not what the big problem with illegal immigration currently is. There is identity theft, but in the main, people are not having their identities stolen in total. Birth date, address, name, social security number. That's not what most illegal aliens who seek to work in the U.S. or in West Virginia have with them.
All right, thank you.
Does the gentleman seek leave for the other gentleman unidentified to try to answer your question?
Sure.
Thank you, Mr. Good.
Thank you,
Sir,
sir.
would you please introduce yourself, take the microphone, and state who you're with?
Yeah, my name is James Massa. I'm the CEO of Numbers USA.
Thank you. Mr. Massey, raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Gentleman from the 20th.
And I'm not aware which question in particular that you're looking to answer. So is there one of the questions I asked the other gentleman that you're looking to provide clarity on?
There was a question. Actually, Andrew, why did I walk up to you? I apologize, but I know you were struggling with the answer.
It was a question about if the employer accomplishes compliance.
Right.
But at that point, the employer had already gone like past 3 days.
Thank you.
How does the employer regain good standing?
One of the things I'd compliment this body on is your elegance on your enforcement. And E-Verify is all about enforcement, and your question's an enforcement issue. So you have a 3-strike type of strategy here. First violation, second violation, third violation, and the body just now removed the issue of taxes being a concern as well, like a tax penalty. If there was still a tax penalty, that would be a confusing situation that you describe. But in the situation you describe as the current amended proposal is before you, it's just a violation. The fact that you didn't participate is a violation. It's one violation. If you hired 12 people or 120 people, it's one violation. Your remedy is to participate in the E-Verify program as soon as possible, register, prove your registration, and then that violation is lifted. And then you're in the period of looking towards the second violation. If that were to continue, you have over 10 years in which you're sitting there looking at that.
So basically, if somebody had a violation at that point, there's no way for them to rectify it.
It is rectified in that you've addressed the violation, you've begun to participate in the program. That's what you're called to do, according to your enforcement.
And what I was looking at, though, is where was you have a signed affidavit. I'm sorry, I'm looking for the penalties section. Let me get there real quick. So upon a first violation, they may suspend the business license of the employer for up to 10 days, or until compliance is accomplished.
That's correct.
It's a guaranteed, what I'm asking is, isn't it a guaranteed 10-day suspension on a first violation of the license, since there's no way for them to meet compliance because they're already past that 3-day threshold?
You're standing up. Counselor, did you? Oh, okay. So when you sign up for E-Verify and do your memorandum of understanding, you come into compliance. It does not take long to do that, and that's when you would have resolved your issue.
See, and that's where I disagree with your interpretation of the language, because sub B that says, effective January 1st, 2025, every employer shall enroll in E-Verify, and thereafter, according to the federal statute, regulation that enrolling, I agree with you. They've enrolled, they're in there, but they shall verify eligibility employment of new hires through E-Verify within 3 days after the first pay to work day. they can't do that at that point because they've already not done it, if that makes, and the memorandum of understanding is past that. So anybody that does not get a memorandum of understanding with the federal government by January 21st, 2025, will have their business license suspended for 10 days if they're inspected by the Department of Labor. Is that correct?
My understanding of your law that is proposed is that they would have it until it's resolved, and they could resolve it in less than 10 days.
All right. Thank you.
Other questions of our witness, Mr. Massa? Gentleman from the 65th.
Thank you, Mr. Chairman. Thank you, Mr. Massa. I was wondering, are there any religious exemptions for this, such as like Amish people who don't use computers? Are you aware of that?
I'm not aware of that.
Okay. Are you able to e-verify yourself?
You are. In fact, it's one of the things that my associate mentioned. You could do it yourself. You go in, you can put in your social security number if you're a U.S. citizen.
Okay.
If you were someone who was here working with another work authorization, you could put that number in, and it'll come up and tell you.
Thank you for that. So if you, say, I'm an employer, and everybody I hire, would I be allowed to have them e-verify themselves once they're hired?
Yes, they could e-verify themselves at any point in time, yes.
So I can make all of them an administrator and do their own e-verification?
No. Well, let's see, that's a very interesting thing you propose. Make everyone an administrator, have them do their own e-verification. I don't think that's the purpose of self-verification.
Well, I know, I'm just, you know.
Yeah.
Is that legal?
Yeah, you do raise something I wanted to mention, and that is that when you are an employer, this is a go-forward situation. So when E-Verify becomes a law that's mandatory, then you do not go back and e-verify everybody who you've ever employed. You only e-verify the people going forward, and that's where the 3-day window is and the 10-day window, all that type of stuff. So it doesn't, the reason that's important is there may be those who are out there knowingly or unknowingly have violated the law and hired someone who doesn't have a work authorization. You don't want to disrupt their workforce, and the intention is not to disrupt their workforce. The intention is to make sure that its work authorizations are checked going forward.
Right.
So the law just allows you to say.
I-9, so when they were in the 80, was 86 or something like that?
That's right. However they were on before is however then before. And then you, since now you're in compliance, then you have the presumption of innocence going forward with everything. So it's a real benefit. It's a benefit to small employers as well as large employers.
Thank you very much for your answers. I appreciate you. Thank you, Mr. Chairman.
Other questions from Mr. Massa? Gentleman from the 100th.
On the ComSub, you had mentioned earlier that it's easy to get back into compliance, and that as soon as you're in compliance, you can get your license back. That's what I think I heard.
On the first violation, that's my understanding, yes.
But on page 7, line 24, it says, or 23, 24, suspend the business licenses of the employer for up to 10 days or until compliance is accomplished, whichever is later. And for a second violation, it's 60 days or until compliance is accomplished, whichever is later. So that would imply that this is not a quick process to get back simply by getting into compliance. It actually could be an extended period because it would be at least 10 days. Even if your compliance was accomplished within hours, it seems that this ComSub states that it would be at least 10 days for a first violation, 60 days for a second violation, which for many of our small businesses would be pretty harmful to their ability to continue to operate.
Yeah, thank you, sir. I'm reading the text now. You're correct. You're reading the text as well. It's a good point. It might be room for continued refinement.
Very good. Thank you very much. Thank you, Mr. Chairman.
Other questions of our guests? Thank you, Mr. Massa.
Thank you.
Does any other member seek leave to call another witness? Gentleman from the 8th.
Thank you. I'd like to see if the sponsor of the bill would yield. That's the gentleman from the 68th.
Gentleman yield? Gentleman yields.
Thank you. We can get way out in the weeds here sometimes. So I just want to ask you some pretty basic questions, if I may. What are we trying to fix here, Chris, with this bill?
We're trying to address the flood of illegal immigrants into the United States, and the number one magnet for that is the ability to work here and largely send money back home. And until we cut off that attraction, we're not going to see a change at the border.
So is this an issue that we're faced with right now in this state?
Our state, very fortunately, is one of the lowest percentages of population that's illegal, and I would like to do my best to keep it that way.
Would you agree that this is like a preemptive strike?
Yes, it's certainly a preemptive measure.
Okay, and then to talk just for a minute about E-Verify. You understand probably much more about this than I do, but this is not a target against employers who are doing it right already, is it?
No, it's certainly not intended that way. It's intended to have everybody on the same playing field and protecting good actors from competing against bad actors.
So there's also been talk about employers with under 14 people or under 15 people, and there's also talk that number should be increased to, let's say, 50. What would that do to this bill?
I think that'd have a very detrimental impact on the bill because that would include most of the employers in the state and would undermine the entire point.
So do you think it would neuter the bill?
I think it would go very far in that direction, yes.
Okay, thank you. Thank you for yielding. Thank you, Mr. Chairman.
Other questions of the sponsor? Gentleman from 20th. Gentleman yield?
I will.
He continues to yield.
Just a question on that, and we went through a few questions. How, and I'm trying to get to the point of these stipulations, and first offense in the original bill was basically first offense was the suspension of the license originally, but in the initial bill, but this is 10 days, and I'm really concerned about the language that says whichever is later. So if you could, and I don't see any way you
I
could
would
come
be
in
open
compliance.
if the gentleman wishes to amend the bill to strike the later, and then that would put them back in compliance as soon as they had complied with whatever violation.
And does it not concern you that that Virginia, which is where this bill's coming from originally, I guess Numbers USA is located, has a number of 50 employees?
Yeah, that does concern me. I think their number should be lower also. 4% of the population of the state of Virginia right now is illegal immigrants, and I don't want 4% in West Virginia.
And also on this, just taking a license of an employer, what is the reason for taking the license of an employer?
Well, under federal law, states are very restricted in what they can do as far as immigration policy. You're seeing right now in Texas, I mean, we're practically at the point of an armed standoff between the Texas National Guard and federal immigration officers. And so the federal government doesn't allow very many tools for us, but this is a tool in the toolbox.
And I just asked that because I forgot to ask that earlier. Isn't it mandated by federal law that you can't do civil penalties? Licensure is the only avenue?
Yes, that's somewhat open to debate, but as to whether civil penalties would fall under licensure, but yes, that's why we've amended the bill.
And are you concerned about the implication it will be taking a business's license? And also I ask, would you say that it's the federal government should be doing their job on the southern border?
Absolutely, yes.
And that's my question is, they should be, but isn't this obfuscating their job to putting it on the federal, or moving that over to businesses of this state to do the job that the federal government is not doing?
I think it's the obligation of every employer in this state to follow federal law and to not be hiring illegal labor.
All right, thank you.
Thank you.
Sponsor. Gentlemen, yield for questions from the 59th.
I will.
Gentlemen may proceed.
Thank you. Are you an employer?
I am.
Do you have any concerns regarding the enforcement of this legislation?
I do. I don't think it's painless. It will require a little more work from employers, but I think that illegal immigration is an existential threat to this country, and that it's our obligation to do what we can to stem that.
And approximately how many employees would you say that you have?
Around 500.
So will this apply to you?
It certainly will.
Thank you.
Thank you.
Other questions, sponsor? Gentleman from the 8th seeks leave to return to questions of council. Is there objection? Hearing none. Gentleman from the 8th.
Counsel, what would be the effect of removing the phrase on lines 24 and 38, whichever is later?
Okay, so there was a lot of discussion about what constitutes compliance. And Mr. Nassau, I thought had an interesting phrase he used. This is a go-forward situation. And when I read this bill, I too think this is a go-forward situation. So when you look at a violation of 21(1)(b)(3), there are a couple of different types of violations that can occur. One can be that they knowingly employed someone, hired someone, continued to employ someone that is unauthorized to perform work. Another violation is that they're not enrolled in E-Verify. So basically, there's four situations where you could be looking at a violation of 21(1)(b)(3). So now we turn to this question of compliance and how can that be complied. Well, the one thing to remember here is in instance 1 and instance 2, you're dealing with the Administrative Procedures Act, which requires written notice and an opportunity to be heard. Those aren't just words. Those trigger certain time frames. In the Administrative Procedures Act, that means that at least 10 days has to pass between the written notice and any sort of hearing on that. So now, turn your attention to the com sub. It says that they suspend the license of the employer for up to 10 days or until compliance is accomplished or later. This is if the employer accomplishes compliance with this article prior to the start or prior to completion of any administrative action. So right there, right off the front, you're looking at 10 days where an employer is going to have absolute notice, hey, you're not E-Verified. Oh gosh, I'm not E-Verified. I better go enroll. You've just now established compliance with that during the administrative practices. So it doesn't go straight to suspension. There still has to be a notice and intent. You still have to have notice and opportunity to be heard. And again, our law requires 10 days. In a third instance, you're talking about a circuit court. Circuit court answers are typically 20 days once you're served with a complaint. Can be extended in some instances to 30 days. So it's again, you've got a period of time. And during those time frames, because there's no findings against the employer, they continue to have their license. They continue to be able to employ their employees, and they continue to be able to do work. They also can use that time frame to, let's say the allegation is we didn't verify who you've hired. They can E-Verify at that point. They can demonstrate through sworn affidavit. We have now looked at our employee pool, and we have E-Verified all of our employees, and they are now, and guess what? All of our employees are now E-Verified, and we do not have any unauthorized employees. Include your memorandum of understanding to the state, show that you've complied with that, and complied prior to any findings, then everything gets removed, everything gets dismissed. You're not found to be in willful or knowing violation, and you have now established compliance. That is how I could see where you're going to have, it's not that the Commission of Labor can walk in and say, I suspend you. That's not the way this is drafted to work. Commission of Labor, based upon a complaint, could say, I'm instituting an Administrative Procedures Act proceeding against you.
Okay.
Here's what I'm alleging. We'll have court in 10 days. In that 10 days, you comply, you provide the proof that's in the committee substitute, the Administrative Procedures Act is dismissed, you're not in violation, you're considered compliant. That's how I would read the committee substitute, both on first violation, second violation, and third violation. Your question was, suspend the license for up to 10 days or until compliance is accomplished, whichever is later? What would be the effect of removing whichever is later?
That phrase, yes.
Well, if you've got an employer, and I hate to use the word, and they're so obstinate that they went through an administrative
Please use
procedures action, got a ruling from that hearing examiner, and then it realized they're suspended, and then after 10 days still haven't taken action, then they would still be subjected to being suspended. One would hope that an employer of a company that meets the requirements of this code throughout the pendency of a court action and the suspension would act to e-verify their employees and to enroll in e-verify depending upon the type of violation. If you were to remove the language, whichever is later, however, in this instance, it would just be discretionary with the administrative law judge in this instance to whether to suspend for 10 days, or an administrative law judge could say you're suspended until compliance is accomplished. I don't know if there's really any import of removing the language, whichever is later, the way the ComSub is drafted.
So what you're saying is you're not sure, you don't know that it does any damage to take it out or makes it any better to leave it in?
I don't think it makes a difference to the bill whether it's in there or it's not in there with the way it's currently drafted. Because the way it's currently drafted, it states that after notice and opportunity to be heard, there can be a suspension of licenses of the employer for up to 10 days or until compliance is accomplished. That could be, again, if you've got an employer that just won't comply, that could be an indefinite period of time in that instance.
Thank you.
Yes, sir.
Other question of council? Gentleman from the 100th, followed by gentleman from the 20th.
In the event that this language is removed and an employer still fails to comply within 10 days, would that employer then be guilty of a second violation? And would that then create the circumstance of having 60 days suspended the license? If they're not in compliance, they're not in compliance.
If it's a continuing transaction, I would argue that if it's a continuing transaction, then it would still fall under the first offense allegation. There would have to be, in my opinion, a new instance of an allegation of continuing to hire or not be verified in the E-Verify system.
Would that be if they continue to retain employees that were not verified in E-Verify?
In this instance, under your hypothesis.
Yeah, what I'm looking at is whether or not a company that is employing individuals and is not properly vetted through E-Verify, and it surpasses the 10 days, would that in fact be a first violation, or would that be a second violation?
No, it'd be a first violation under the way the ComSub is drafted, because right now it says suspend the business license of the employer for up to 10 days or until compliance is accomplished, whichever is later. So if they remain in a situation where they do not act to become compliant, then they are going to continue to just remain suspended under that first offense because of the way the ComSub is drafted.
So they would have to eventually get into compliance for them to be, okay.
For there to be a triggering of a second violation.
Understand.
Yes,
okay.
sir.
Very good. Thank you.
Gentleman from the 20th.
And I hate to belabor the point, and I understand what you're saying, if they get in compliance, so first, under B, the employer must E-Verify, sign up for the E-Verify by January 1st, 2025.
Under Section 3?
Under Section, yes, 3.
Yes, effective January 1, every employer shall enroll in E-Verify. Yes.
Okay. So, second, they need to verify every employee.
Yes, within 3 days of the employee's first day of work for pay.
Okay. So, let's say we've gone through the point of Department of Labor saying you're not in compliance because they did not sign an MOU, let's say instead of January 1st, they did it in October, for example, and obviously probably hired several employees in that time frame. So they're in violation because they did not sign up and get an MOU by January 1st if they're in their office saying you didn't do that. So Department of Labor says you're out of compliance, you must get compliance within 10 days. We're at that point of saying you must get in compliance with 10 days, or you're either banned for 10 days or you must get in compliance, whichever is later. And this is where we disagree. If I read from the E-Verify, it's nice big hefty manual. Participating in E-Verify, an employer must not create an E-Verify case for an employee who was hired before the employer signed the E-Verify MOU, except in certain circumstances, federal contractors with FAR E-Verify clause. I'm not familiar with what that clause is, but if they can't create a case so January to October, they've had employees. How do they get in compliance if they can't create a case for somebody who's already been employed in violation? I don't understand how we get there. And if you say whichever is later, they'll never get in compliance. It's an indefinite ban of the employer's license or revocation of license.
The answer I would give is subsection A of Section 3, which says that no employer may knowingly and willfully hire for employment or continue to employ an unauthorized alien. And I recognize what the gentleman has read from I'm guessing that's a manual, if I'm not mistaken. I understand what the gentleman has read from the E-Verify manual. However, West Virginia law in this instance would address a situation where you are continuing to employ an unauthorized alien, which would allow you to then act within the time frames in A, B, and C of Section 5 to act in compliance.
And that's where I come back to, if they can't create a case to verify an employee, how do they get in, because that employee was hired before that date, do they have to fire them and rehire them and redo it? Because then you can't create a new case.
I think in this instance it would, and I'm not playing semantics with you here, I think that if the allegation is that you hired and continue to hire an unauthorized individual, then you would have to demonstrate, and compliance would consist of, 1, I am now an E-Verify, 2, I am not continuing to employ unauthorized individuals, or I have no unauthorized individual employees. Now, if the manual of the E-Verify would preclude that sort of compliance, then we turn back to the provisions of the ComSub as it's drafted. Accomplishment of compliance with this article shall include submission by the employer of a signed sworn affidavit stating that the employer is in compliance with the provisions of the article, and a copy of the memorandum of understanding issued to the employer at the time of enrollment of E-Verify. So in that situation, if you could not create that case, then compliance would be satisfied by showing that, to use the gentleman, Mr. Mass's term, forward-looking, you are now enrolled and you will You will be bound by the terms of that memorandum of understanding moving forward.
But if we removed that language, that would be in the decision of the administrative law judge in case we do come up against a situation where they cannot satisfy due to the rules of the federal E-Verify law. So for the whichever is later language.
Okay.
The administrative law judge would say whether it would be 10 days or compliance. Let's say, for example, the determination was there is no way possible to get into compliance. Then they wouldn't be indefinitely barred. The administrative law judge to say, well, you're barred for 10 days because you can't get in compliance, or they could say in compliance with, would they be able to say within compliance of one or the other, the law judge? For example, just say they signed the MOU?
Well, all I would say is that accomplishment of compliance, as drafted in the ComSub, specifically states if the employer accomplishes compliance prior to the start or prior to completion of any administrative action. So you've got that time frame, prior to the start or prior to the completion of the administrative action. The license shall not be suspended. And then the ComSub goes on to define what means. I mean, it doesn't say specifically this is a definition, but it explains that accomplishment of compliance shall include submission by the employer of a signed sworn affidavit stating, and I won't belabor everyone because we've said this several times, but that the employer is now in compliance and with the provisions, and a copy of the memorandum of understanding, which it's my understanding is provided to every person that creates an E-Verify account on the E-Verify system.
And as an employer, I guess I'd have to get a lawyer involved to figure out if I was in compliance, because I wouldn't be able to sign an affidavit because I don't see any way I could get in compliance, so that would be an illegal swearing.
I think you could swear. I think you could swear to an affidavit that says that you are now enrolled in the E-Verify system, that you have accounts, and that moving forward you will E-Verify all new hires as per your new policy of your company. That would not be a misrepresentation, and it would show that you are currently moving forward compliant with the E-Verify requirements of this ComSub.
All right, thank you.
Yes, sir.
It's less clear now.
Other questions of council? Gentleman from the 65th.
Thank you, Mr. Chairman. Thank you, council. So, council, if I'm a business owner and I have 10 employees, am I required to do the E-Verify system?
No.
If
Not
after
under this
2025, I employ 10 people and then business is good, and I hire 10 more people, then I must start the E-Verify system once I reach 15 employees?
That would be correct. At 15 employees, once your business grew to that point, to 15 employees, you would have to implement a change in practice, and one of those changes in practice would be to enroll in E-Verify moving forward.
If I then had bad business and then I lost and I'm under 15, am I required to continue the practice, or am I then exempt again from using the E-Verify system?
If you go less than 15, again, you fall back into the proviso under the definition of employer, which specifically states that employers who employ fewer than 15 people are not employers for purposes of this article.
Thank you, council. Thank you, Mr. Chairman.
Other questions, council? Question of council. Any other members seek leave to call a witness? All right, you can stop holding your breath. Are there amendments? We have amendments at the podium. We have 3. Gentleman from the 20th seeks to amend the committee substitute on page 5, section 3, line 23. by striking the word January and inserting in lieu thereof July. The gentleman need to explain that amendment?
The only thing I would say is this is to comply with, make sure that the rules that are drawn up by the Department of Labor are passed the full legislative process before we institute this law.
Questions of council regarding the amendment? Gentleman from the 42nd.
Council, I understand that we're talking about employment here, but just as one lawyer to another, the effect of a statute is that a person follows the statute, and the effect of a rule is that a rule clarifies and adds to or enables a statute, but it's not necessary to have a rule for a statute to be in place. A statute supersedes a rule, correct?
Correct.
So if it was between January and July of 2025, the employer would just follow the law, much like the law we have on murder. I mean, we didn't have the Supreme Court come up with a rule on murder. We just have a statute, right?
That's correct, sir.
Thank you.
Other questions of council in regard to the amendment? Any member seek leave to call witness on this amendment? If not, we are voting on the amendment. All in favor signify by saying aye. Aye. Opposed, no? No. The noes appear to have it. The noes do have it. Division has been called. If you are in favor of the gentleman from the 20th amendment, raise one hand, please. If you are opposed, please raise one hand. On that amendment, there were 10 yeas, 12 noes. The amendment is rejected. Second, the gentleman from the 20th seeks to amend the bill on page 5, section 3, line 21. By adding new language after the word employer as follows, including employers with less than 15 employees. Does the gentleman seek leave to explain his amendment?
Yes. So what this does in sub A on page 5 is add less than 15 employees because we already defined an employer as more than 15 or 15 or more employees. So basically it's as this is drafted, it would make it legal to hire for employment or continue to employ an unauthorized alien to perform work in the state of West Virginia if you had less than 15 employees. So I'm trying to fix that and make sure that for that section, the 15 employees stipulation doesn't apply.
Questions of council? Gentleman from the 68th.
Counsel, is your interpretation the same as my friend from the 20th on the effect it would have without this amendment if we adopt the bill?
I tend to agree with the gentleman making the amendment that this language, because I want to say the intent of the bill is that there is a prohibition that any employer, regardless of size, would not hire for employment or continue to employ an unauthorized alien. This amendment would make it clear that any employer of any size would have that prohibition over them. I think it would add clarification language.
Do you see where it does harm anywhere else in the bill?
I don't think it does harm to the other parts of the bill at this point. I'm sorry, I'm just getting it for the first time.
Understood.
And one could also argue that perhaps it might be better placed under C, just because the provisions of this article do not apply to the following. But again, I don't think that gets to the amendment as well. So I don't think it does harm to the bill in its entirety. No, sir.
Thank you, counsel. Thank you, Mr. Chairman.
Gentleman from the 42nd, followed by the gentleman from the 88th.
So if I go back here, employer is back on page 2, and that employers who employ fewer than 15 people are not employers for purposes of this article. So for the entire article, the term employer does not apply to anyone who employs less than 15 people. So if we add in there the new language, comma, so no employer, comma, including, could you say it again? Mr.
Including
Chairman?
employers with less than 15 employees.
And then a comma again,
Yes.
may knowingly and willfully, which is essentially a restatement of the law that's already on the books in West Virginia, right?
That's correct, sir.
And it doesn't modify employer over on page 2. So really, all it does is reiterate that it's illegal to employ an unauthorized alien here in West Virginia, but it does not attach the E-Verify requirement to those employers with less than 15.
That's my analysis.
Okay, all right, thank you.
Yes, sir.
Gentleman from the 88th.
Thank you, Mr. Chairman. The gentleman from the 42nd basically addressed my question.
All right, gentleman from 20th.
And I would ask unanimous consent to reform my amendment to say regardless of number of employees, in case other amendments were to pass that would affect that employee number.
The gentleman seeks leave to reform his amendment. Hearing no objections, here you can just write it on there. Yes, gentleman from 100. Gentleman may proceed. Question of counsel, yes.
So, in the event that this language...
Can you get your microphone there, please?
In the event that this language would not pass, that the current verbiage is retained within the COM sub, would there be any kind of conflict between current code and this COM sub?
There potentially could be because of the proviso in the definition section, and this would add clarity that any employer of any size has that prohibition. So I think it is an amendment that clarifies necessarily.
Very good. Thank you, Mr. Chairman.
The gentleman from the 20th revised amendment seeks to add after the word employer, page 5, line 21, the following, regardless of the number of employees. Any other questions of counsel? Discussion? If not, all in favor of the gentleman's amendment signify by saying aye. Aye. Opposed, no. The ayes do have it. The gentleman's second amendment from the 20th is adopted. Next and last, we have an amendment from the gentleman from the 100th seeks to, just wishful thinking. They got buried. Gentleman from the 100th seeks to amend the bill on page 7, sections A and B, on lines 24 and 38, removing the words whichever is later. Gentleman seek to explain his amendment.
Yes, this simply provides some degree of discretion that I think is necessary to allow businesses to return to both compliance and reobtain their licenses so that they can proceed with business as quickly as possible, and to continue to employ West Virginians. And I think that's a goal that all of us have. Thank you.
Questions of council? Questions of council? Discussion? Council?
Could you restate that amendment again?
Yes, on page 7, lines 24 and 38, remove the words "whichever is later." Question of council?
Yes, sir.
You may proceed.
Thank you, Mr. Chairman. So, I mean, obviously, I didn't draft the bill, but to me, you know, there's been some discussion of teeth in this bill, and due to federal law, our inability to create a criminal or civil penalty, the most that we can do is affect the licensure of someone who, as we say, in A and B, knowingly and willfully violates this law. First violation, second violation. So given the fact that we cannot impose a criminal or civil penalty in these situations, the whichever is later part seeks to impose the only penalty the feds have left us with, which is suspension of a business license. And much like if I failed to file an annual report, or if I failed to file my 941s, or I failed to file my, W-2s, or send them off to my employees, I could have my business license suspended. This, to me, the whichever is later, intends to be somewhat of a punitive action, which is the only action that we can carry out. Am I right?
I would agree with that, sir.
Okay. Thank you.
Other questions of council? Leave to call a witness. Discussion. Gentleman from 20th.
And given the discussion we had here today, I would support the gentleman's amendment because, we had spent 40 minutes trying to determine if someone could even come in compliance with this law. And when you say whichever is later, you got to remember you're saying whichever is later as in, you're saying whichever is later as in the 10 days, or in the other instance, the 60 days, or until compliance is accomplished. The compliance is with the entirety of the E-Verify law. And according to the manual, and whenever you ask to verify someone who's not, there's no possible way to verify employment of an employee without first firing them, then rehiring them and running them through. Like, let's say you do get to the point where, okay, I'm in the memorandum of understanding, I'm going to E-Verify. Well, you can't verify that employee until you have first fired them and then gone back and rehire them. And if we strike this, it just puts it in the hands of the administrative law judge to make that decision. So it's not that it's just removing it, and we didn't change. It's not changing. And I think the gentleman made a correct decision, not changing it to whichever is sooner. He made the decision to leave it in the hands of the administrative law judge. So if we do come up against the situation where somebody cannot come into compliance, the administrative law judge could say, okay, 10 days, since there is no way for you to come back into compliance. So I would support the gentleman's amendment.
Other points of discussion? If not, gentleman from the 42nd.
I would have to say that the way that I had originally read this, given our limitations from the federal side, and I have to say, I know everybody in here knows I'm a lawyer, but I also own businesses too, and I E-Verify people all the time. It takes like 30 seconds. It's not that big of a deal. And we have a PEO that does it for us. So the topic of discussion about, can a staffing agency or a PEO do it? Absolutely they can do it. They do it for us all the time, and it takes absolutely 30 seconds. You're already doing an I-9. You're already filling everything out. So how hard is it to E-Verify? And to me, if we're going to force compliance, and we're looking at, gosh, I get people sending me videos all day long all day long, every day, of people pouring over the border and it's stories out of Texas and everything else. And guess what? It is showing up here. You know, you look at the bills that I've been putting out about human trafficking and everything else, you think it's to score points? No, it's because we got a dang problem here. We got people that hate America, hate us, hate our way of life, and hate our values that are coming in here and taking West Virginians' jobs, and we're trying to do something about it. And if I got an employer that is not going to abide by a simple guideline like this that takes about 30 seconds, then yeah, I want them suspended for 60 days. Yeah, I want them suspended for 10 days, not just in the time it takes to get into compliance. How about we look at the drug dealers out on the streets? Like, okay, if you'll just get rid of the drugs, we won't put you away for 1 to 15 years. Just get in compliance. Just because somebody owns a business does not mean that everything they do is honorable, and we got to give them an excuse and a pass for all of it. This is a very easy law to comply with. And I own 2 different businesses that do it. And we do it through a PEO, and it takes 30 seconds. This is not that big of a deal. If somebody's skirting this, I would want to see that they actually go through a period of time where this is actually going to affect them, rather than skirt the law. And I would urge rejection of the amendment.
Other points of discussion? If not, all in favor of the gentleman's amendment, signify by saying aye.
Aye.
Opposed, no?
No.
Noes appear to have it. The noes do have it.
Point of order, Mr. Chairman, to the gentleman not to get to close debate on this amendment. I'll waive my ballot.
Late, but good point. Very well. The gentleman from the 20th, yes, the gentleman from the 20th seeks to amend the bill. We'll start in the order that they appear on page 2, line 2, section 2, page 2, line 31. Striking the word 15 and inserting in lieu thereof 50. The gentleman seek leave to explain his amendment. May proceed.
Very simple. This would apply to 50 people. I think this is something that would be helpful for applying to 50 people. That's going to apply to businesses that are more able to comply with this. This is going to be something costly. I know the gentleman from the 42nd is saying this is easy. This is something that is not going to be as easy as stated, and it does have many consequences. Now you just lose your license for indefinitely, apparently, whenever you have on a first offense. So that's going to be difficult. But I think it should apply to people that have the means to be able to go through this E-Verify system. Otherwise, we're just hurting small businesses in this state by making them go through more red tape, more government process. It's something that is not going to benefit your small business in the state, getting people hired and moving through. So I would urge adoption of the amendment.
Questions of council? Do you remember a question of council, gentleman from the 42nd?
At the appropriate time, I'd ask to recall Mr. Kersey from the Secretary of State's office.
All right. Questions of council first? No, Mr. Kersey, you please take the microphone. You're still under oath. Gentleman from the 42nd.
Thank you again for sticking around for this. I know that I've seen stuff come out from the Secretary of State in the past, and I would hate to have the facts wrong, but I know that the vast majority of West Virginians are employed by what we would consider to be a small business. Do you have any idea off the top of your head how many West Virginians would be employed by employers less than 50 versus less than 15?
I wouldn't. I apologize. That may be a good commerce question, perhaps even tax, but not our office.
Okay. Okay. Thank you.
Additional questions of Mr. Kersey? Thank you again, Mr. Kersey. All right. We're on the gentleman's amendment, changing 15 to 50. Other points of discussion? Gentleman from the 188th, followed by the 8th, followed by the 68th.
Thank you, Mr. Chairman. I'm opposed to this amendment because I think changing it from 15 to 50 would eviscerate the intent of it. I know we've had an awful lot of discussion here today with regards to how difficult or not difficult this is. It's my turn for show and tell, I guess. I was hoping to show you how fast it would be to do this. Although we've been at this for quite a while, this did take about 30 seconds to e-verify myself. Sign up, et cetera, all the rest of that. This is not that complicated. I think the intent of the bill is to do the various things that were discussed earlier with regards to stopping illegal employment of illegals. I do not support this amendment.
Gentleman from the 8th.
Mr. Chairman, I'm not going to belabor the point. I will say that I believe, according to the sponsor of the bill and other discussion that we've heard here today, that this is nothing more than a poison pill designed to damage, possibly beyond repair, what we're trying to accomplish here today.
Gentleman from the 68th.
Thank you, Mr. Chairman. I'd just like to reiterate those points. Most of business in West Virginia, most employers fall under that threshold by far, and we would eliminate any positive impact from this bill if we raise the number that high. And I would urge rejection of the amendment. Thank you.
Gentleman from the 44th.
Thank you, Mr. Chair. I urge adoption of the amendment. I don't think anybody in here that ran on making life more difficult for small businesses. When I go around to my district and I go to different small businesses in particular, whether it be 15 or 45 or 55 employees within that business, what I see are help wanted signs. What I see are people that are begging for workers. I don't see illegal immigrants taking those jobs. I don't see anybody taking those jobs because we have made the business climate in this state so difficult. I think this is just going to add another barrier to small businesses, which should indeed fall within the 50-employee amendment that's being offered. I think that's the least we can do to make this bill more manageable for our businesses in this state, and so I urge adoption of the amendment.
All right. Before we move on further, I was just handed another amendment which is competing with this amendment. It seeks to change the word 15 to 20 from delegate from the 65th. So obviously one would cancel the other. So gentleman from the 65th seek leave to explain his amendment. Pretty self-explanatory. So, other points of discussion on both amendments. Gentleman from the 79th.
Sponsor, would the gentleman from the 20th yield?
Gentleman yields.
How did you choose 50? Is that a threshold that's commonly used for other provisions?
Yes, there's other states many other states that have 50 as the threshold. And so that was one of them. I mean, I have a list of states here, but going through different requirements and stuff. And, I mean, Numbers USA stated in Virginia that people that proposed this said they only have to if they have 50 employees in contract with the state. So I figured, I mean, the people asking us to pass this legislation are under that requirement. I feel like it's something that is reasonable.
And have you looked at some other federal regulations that kick in with the number 50 employees?
Well, and quite frankly, for example, small businesses can get assistance from the DEP in our state based on the fact with air quality permits or other issues. I know you're familiar with many of those. Based on the standpoint of 100 employees, but I felt like 100 was too much, so I went with the lower number being 50. That's something that other states have addressed.
And so some of these federal requirements that I was asking about, like the Family Medical Leave Act or some Affordable Care Act provisions or some provisions related to affirmative action, those all kick in at 50, right? So that's a common threshold
I'm not
that's
sure
used.
at exactly what they do kick in. My understanding was it was anywhere from 50 to 500, depending on which piece of legislation that you select.
Did you say 50 to 500?
To 500, yeah.
Okay, thank you. Thank you, Mr. Chair.
Other questions? Yes.
Which amendment are we on at this time?
We're on the delegate from the 20th Amendment, changing from 15 to 50. If that amendment fails, if it's adopted, then the gentleman from the 65th Amendment will be moot. If the gentleman from the 20th Amendment fails, then we will vote on the gentleman from the 65th Amendment.
Okay, so basically you advised that there was another amendment that's competing, but that amendment's not before us right now. Okay.
Well, exactly, they're competing, so we're going to take up the gentleman from the 20th Amendment first, yes.
Thank you, Mr. Chairman.
Gentleman from the 5th.
Chairman,
Yes, sir.
the amendment before us was offered prior to the competing amendment being offered. If an amendment's already before the body, can a competing amendment be offered at that time, or does the competing amendment have to be represented to the gentleman making the current amendment as an amendment to the amendment?
My point is that we are in the amendment stage, and not necessarily simultaneously, but both amendments were presented to the chair, and therefore we will vote on these as I just outlined to the gentleman of the 76.
All right.
Other points of discussion on the gentleman from the 20th Amendment to change 15 to 50? If not, all in favor signify by saying aye. Aye. Opposed, no. No. And those appear. All in favor of the gentleman's amendment, please raise one hand. If you are opposed to the gentleman's amendment, please raise one hand. On that vote, there were 8 yeas, 15 noes. The amendment is rejected. That brings us to the gentleman from the 65th Amendment to change 15 from 20. Therefore, an employer would have to have 20 or more employees to be included. Gentlemen, he waived explanation. Are there questions of counsel regarding this amendment? Any member seek leave to call a witness? Points of discussion. Gentleman from the 86th.
Chairman, I was somewhat encouraged when I heard there was a competing amendment. I was thinking it was going to go to 10. Seems like the gentleman that sponsored this has 500 employees and is the least concerned about any of the sanctions that may come against an employer, because he's going to bend over backwards to do it right. That's the intent of this bill, and to have more discussions about whether it's 15 or 20, kind of defeats the whole purpose. I would reject the amendment.
Other points of discussion? If not, all in favor of the gentleman's amendment signify by saying aye. Aye. Opposed, no? No. The noes appear to have it. The noes do have it. The gentleman's amendment is rejected. The gentleman from the 20th seeks to amend the bill on page 8, line 11, section 8, page 11, line 14, striking the word shall and inserting in lieu thereof the word may. That's one part of his amendment. And then on line 19 and 20, by striking the remainder of the paragraph after the word article and inserting a period. And on line 20, insert a new paragraph, B, in parentheses, to read as follows. Public notification provisions. 1. The Division of Labor shall post educational information and material about the E-Verify program on the Division of Labor's website, along with any other notification the Commissioner approves to make employers aware of the provisions of this article. before the effective date of this article. 2, the Secretary of State shall notify the service of process agent or individual authorized to file annual reports on behalf of the employer of the E-Verify provisions of this article for each business registered with the Secretary of State before the effective date of this article. And on line 21 by striking B and replacing it with C. Gentleman seek leave to explain his amendment.
Mr. Chairman, I would move to divide the amendment.
Seems to be a good motion. Where would you like to divide it?
The question appears to me, there's a first question on the line 14, shall becoming may, and then the second question would be the striking after article and the insertion of the new language.
For what reason?
Jeff.
Good thing this one was at number 7.
I understand the motion to divide is not a debatable motion.
I don't think anyone's crazy about debating that anyhow, so. Point well taken. Gentleman for what purposes? Gentleman from 100 seek recognition. Pardon?
Question of council.
That would
Okay,
be
division.
a form of debate. So, all in favor of dividing the amendment, signify by saying aye. Aye. Those no. The ayes have it. We will take up the first part of the amendment on Section 8, line 11, Section 8, page 11, line 14, changing shall to a may. Gentlemen, seek leave to explain the first division of your amendment.
Thank you, Mr. Chairman. And those, I don't see anybody on Rulemaking Review Committee. There's somebody on Rulemaking Review Committee. We're growing and growing in our number of rules, and this has been an ongoing problem of us putting shall develop rules, and then the agency copy and pasting our bill into the rule. So I just want to give the agency the option of if they don't need the rule, then they don't have to offer it, rather than just continuing growing our long list of 970-some rules.
Gentleman from the 8th.
Thank you, Mr. Chairman. I feel like the gentleman from the 20th and I are going to be singing Kumbaya here in a minute, because I agree with him. I sit on rules and rulemaking review, and it is a daunting task when everything says shall. now that we're saying may with this, I think it makes good sense. We bury ourselves in paper. We need to stop doing that. We bury ourselves in these rules and regulations. This is a step forward in making sure that we don't do that over and over and over again. So I support the gentleman's amendment.
Other points of discussion? And I should ask, are there questions of council regarding the amendment? All right, no discussion. All in favor of the gentleman's amendment signify by saying aye. Aye. Opposed, no. The ayes have it. The first part of the gentleman from the 20th amendment is adopted. The second part of the gentleman from the 20th amendment simply requires a division of labor to provide notice on the Division of Labor's website, along with any other notification the commissioner approves, to make employers aware, and it also would require the Secretary of State to provide notice to any employer or business that is required to register with the Secretary of State, and both of those are before the effective date of this article. Gentleman seek leave to explain his amendment.
Yes, and so the first one is the language that was already in the bill, except for I added any other provision the Commissioner of Labor saw fit to provide, because I think we need to provide adequate notice so that this is going out. Otherwise, many employers will get caught up in this. So that and why this was in the other is because I struck, and why it wasn't divided to begin with is I struck the shall and put it to may. Well, that would have said the Division of Labor may. So what I did is just struck that from the section that is now titled may do it, and put it to a new section that said the Commissioner of Labor, the Division of Labor shall provide it on their website educational material. But then also went forward with the Secretary of State's office and had them send notification out to all businesses within the state, letting them know that this e-verification is at issue. And I believe the Secretary of State's office is here. I've had former discussions with them. Please do not change it to a letter or written notification, because then that would just add a very large cost to the Secretary of State, but they can do it. I understand they can do it electronically very simply now to all 150,000 businesses registered in the state.
Questions of council regarding the effect of the gentleman's second part of his amendment? Points of discussion? If not, all in favor of the gentleman's amendment signify by saying aye. Aye. Opposed, no. The ayes have it. The gentleman's second part of his amendment is adopted. Further amendments? Receiving none. The gentleman from the 8th to move the committee substitute as amended.
Thank you, Mr. Chairman. I move that we report the committee substitute for House Bill 4759 as amended to the full body with the recommendation that it do pass.
You heard the gentleman's motion. Is there discussion regarding the gentleman's motion? Points of discussion? If not, all in favor signify by saying aye. Aye. Opposed, no. The ayes appear to have it. The ayes do have it. I declare that committee substitute for House Bill 4759 as amended will be reported to the floor with a recommendation that it do pass. Well, we are certainly on a roll. That's 2 out of 7. So we are going to now move to House Bill 4315, providing DMV with certain medical information. Council, whenever you are ready.
Mr. Chairman, House Bill 4315 relating to providing DMV with certain medical information related to mental or physical disabilities as it relates to the ability of a person to drive safely. Summary is, the purpose of this committee substitute is to provide reports on mental or physical disabilities or disorders to the DMV to determine an individual's medical competency to retain their driver's license. The bill also provides that the amendments to this section shall be known as Michaela, Miranda, and Phillips Law. The committee substitute amends 17B 313A to provide that unless contrary to federal law, healthcare providers, including all physicians, podiatrists, chiropractors, physician's assistants, certified registered nurse practitioners, and other persons licensed and authorized pursuant to Chapter 30 of the Code who diagnose or treat diseases, disorders, disabilities, or conditions shall notify the Division of Motor Vehicles in writing within 10 days of the diagnosis with the full name, date of birth, and address of every person 15 years of age or older who suffers from a physical or mental disease, disorder, disability, condition, or symptoms that prevent the person from safely operating a motor vehicle. Diseases, disorders, disabilities, or conditions, if you'll turn your attention to 17B 313H, includes but is not limited to physical impairments characterized by lapses of consciousness or other cognitive, mental, or physical disabilities affecting the ability of a person to competently drive a motor vehicle. So when a doctor does make this diagnosis, the physical, mental, or disease, disorder, disability, condition, or symptoms that prevent this person from safely operating the vehicle must also be either uncontrollable, either through medication, therapy, or surgery, or by device or technique. 2, controllable, but the patient does not comply with the recommendations of the healthcare provider for treatment or restricted driving. Or 3, undiagnosed, but the extent of driver impairment is potentially significant based upon the patient's symptoms. The committee substitute amends 17B 13B to provide that any person in charge of a mental hospital, institution, or clinic, or any alcohol or drug treatment facility shall be considered a healthcare provider responsible to assure that reports are filed in accordance with this section. The committee substitute also amends 17B 313C to provide that no report by a healthcare provider shall be made solely on the basis of age. I would add that 17B 313 also contains, if you'll turn your attention to what will now be G, that compliance with or failure to comply with the requirements of this section does not constitute negligence, nor may compliance or noncompliance with the requirements of this section be admissible as evidence of negligence in any civil or criminal action. That does still leave open the option that there could be a situation where compliance or noncompliance could be used in a suspension of licensure. So there are still some teeth to this bill, which would require every physician, every healthcare provider defined by this code that I'm aware of takes the status of their licensure very seriously and hold that status very near and dear to their heart. This committee substitute does not forbid any of that information from being used in a proceeding of that nature. And lastly, and maybe most importantly, the amendments in Section I, or subsection I, the amendments to this section enacted in the 2024 regular session of the legislature shall be known as Michaela, Miranda, and Phillips Law. Mr. Chairman, that is the committee substitute.
Thank you, Counsel. Are there questions of Counsel? Questions of Counsel. Gentleman from 42nd.
Counsel, so looking at, I looked over the abstract and I've now got that committee substitute in front of me. So forgive me, we spent so much time on some of the other bills. I haven't really gotten to take a hard look at this as of yet. Are there specific conditions listed in here that would prompt a physician to notify the DMV?
Yes.
Okay.
Well, in the sense of if you turn to H, okay, so H is for clarification, and A provides who suffers from a physical or mental disease, disorder, disability, condition, or symptoms. Okay? That is actually an existing code as we stand today.
Now, where are you at?
On subsection A.
What page?
Page 1.
Page 1,
Yes, sir.
subsection A.
Yes, line 6.
Line 6. From safely operating a motor vehicle which is either uncontrollable through medication, therapy, or surgery, controllable or undiagnosed.
That's correct, sir. And I would also turn your attention to line 44 on page 3, which
That's
gives...
the one I was looking at.
Yeah, which gives further clarification for diseases, disorders, disabilities, or conditions.
So, tell me the difference between the subsection H on 44 and the existing law provided where you read on number 6. Is there a difference?
There's clarification towards lapses of consciousness. There is specific reference to cognitive disabilities that are not specifically delineated in the code as it exists today. I think physical disabilities, yes, physical disabilities is specifically outlined in the existing code of subsection A as it sits today.
But we also have pathways for people with physical disabilities to get vehicles that are designed to help them overcome so that they are mobile. I mean, I have a constituent that was horrifically injured in a mining accident and became paralyzed from the waist down and was able to get a vehicle with hand controls and everything else that he can get around just fine now, and actually has several nice vehicles in that manner. And based on the changes that are getting thrown into subsection H, I mean, with the onus being put on the doctor at that point, is he still going to be able to drive?
I would, I'm sorry, did I overstep you? Were you finished with your question?
No, I'm done.
Okay.
I was done.
I would ask the gentleman to turn to page 1, line 8, wherein there is an exception for, there is a requirement of uncontrollable. And I would look to the driving device or technique, and if it's, and I would argue that a driving device or technique would meet the definition of what you're talking about with the gentleman that you've used in your hypothetical, where someone's lost the use of their legs, but they can, or some other type of driving device is utilized by which they can then operate a motor vehicle safely.
My next question would fall along the lines of, let's say somebody does have a cognitive, mental, or physical disability for which they are getting medicated for. Like, say someone who was injured but, had been prescribed opioids. Is a physician going to be required to inform the DMV now that this person has been prescribed opioids and shouldn't drive?
For a prescription of opioids only?
Yeah.
I'm not sure that a prescription would constitute a triggering event under this committee substitute.
You're not sure?
That a prescription of a certain medication. Now, could the underlying reason for the prescription be a cause for a referral to the DMV? That, in fact, I think would meet the requirements of the committee substitute, depending upon what the underlying ailment is that causes the prescription. I do not read anything in here that says because you prescribe someone an opioid, for instance, that by the virtue of diagnosing that opioid, that a requirement to report is created.
I would ask the same question about someone who's a medical marijuana card holder. I mean, is this going to prevent them from, I mean, or is DHHR just going to turn over all the licenses to the DMV and say, cancel them?
Medical marijuana, you would again, I think, have to look not to the treatment, but to the underlying ailment that would cause the medical marijuana to be dispensed. If it is a cognitive impairment that impacts their ability, I'm using the words of the concept, ability of a person to competently drive a motor vehicle, then I think there would be a referral that would be necessary. I think the analogy of medical marijuana and an opioid are similar in the sense that it's not so much what's prescribed as the underlying reason for the dispensing of marijuana or the prescription in relation to opioids. Of course, there are always concerns that people are using marijuana and driving a vehicle. There's an obvious problem with that. But the same can be said with any number of medications that are regularly prescribed by a physician.
Well, and I guess the source of my line of questions is coming from language that appears in the new subsection H that does not appear in the old subsection A.
Yes, sir.
15 years of age or older who suffers from a physical or mental disease, disorder, disability, condition, or symptoms that prevent the person from safely operating a motor vehicle. And then you have your three, the uncontrollable, controllable, but not complying, and undiagnosed, but based on symptoms. But there's new language, and one particular phrase added to subsection H, but is not limited to. So if we have, for the purposes of this section under H, diseases, disorders, disabilities, or conditions includes, but is not limited to, physical impairments characterized by lapses of consciousness or other cognitive, mental, or physical disabilities affecting the ability of a person to competently drive a motor vehicle. So in my take on it is, under the existing law, the actual physical, mental disease, disorder, or disability, or condition, or symptom would be what would prevent you from driving the vehicle. But with the addition of, but is not limited to, it could also include the treatment, which would negate the controllable through medication. Because there are a lot of medications out there that have on the side of them, you shouldn't be operating vehicles or heavy machinery. And as a healthcare provider at that point, due to the but is not limited to, are they going to be put in a position when they give a medical marijuana card, or they prescribe an opioid, or they prescribe lithium to help someone with their cognitive disorders, or they prescribe, something else of a mind-altering nature, and maybe not mind-altering as much as physically impairing nature, are they now going to have to report that to the DMV, and the DMV is going to be required due to that one section, but is not limited to?
to the gentleman's question, I think that the language, "but is not limited to," could create an open-ended situation, which could create confusion in a situation where you've got a medical provider who maybe sees things in a certain way. So to that point, I do see the gentleman's point to the language of "but is not limited to."
Thank you, Mr. Chair. I'd ask at the appropriate time, leave of the committee to call a couple witnesses who are here today that can shed some light on this.
Let's go ahead and do that. Who would you like to call?
I'd like to call first Amber Kirk, if I could, and following that, Melissa Buttrick. And I would also ask the chair for some leeway as they give this testimony so that they can do it in a narrative form without interference, as much interference as possible here, so they can share their story.
Ma'am, would you please introduce yourself, and then I will swear you in.
Yes, sir. My name is Amber Kirk. I am the mother, the bereaved mother of a child killed in a very similar incident in what we're speaking of today.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Kirk, thank you for being here, and thank you for being willing to share your story. I can't even begin to imagine how difficult this is going to be. That's why I asked the committee for some leeway. Can you share your story with this committee, please?
Yes, sir. First of all, thank you all for the opportunity to come here and speak today. Like I said before, my name is Amber Kirk. I'm from Fayette County, West Virginia. And introducing myself, I'd like to tell you about my daughter, Michaela. This is her. I want you to put a face with the name. She's not just a statistic. She's my daughter. She was an aspiring college student on a full medical scholarship at Marshall University in the pre-med program. She had her entire life ahead of her. This statistic could very likely be your daughter, your granddaughter, your mother, your father, your grandparent. It's not a matter of if, it's a matter of when this is going to happen, again, if you do not make a change in this policy. Michaela had just returned home from school, from Marshall University on a Friday evening. She actually came home from school for the sole purpose of taking one of her best friends to dinner at a local Mexican restaurant in Oak Hill. That friend was Philip Dickerson, also a casualty in this incident on his 19th birthday. Following dinner and en route back home, Michaela and her passenger, Philip Dickerson, were killed when a vehicle traveling the wrong way collided with them in a head-on collision on U.S. Route 19 in Oak Hill, West Virginia. The elderly driver of this vehicle also perished in that crash. Nothing can prepare you for the loss of a child who has her whole life in front of her. Until you lay over that dead child and you beg and you plead and you ask yourself, why my child? For a long, long time, I have searched for purpose in her death. You have an opportunity today to make that purpose with a change in this bill. That fatal accident could have and should have been prevented. I urge every single one of you today to listen to my words, to let it resonate in your mind and let it resonate in your heart that this will happen again. I want to start by explaining that the other driver, whom I'll refer to as Mr. Bennett, was reported out of concern earlier in the evening to the county 911 center by his own immediate family after not returning home early in the evening for a quick outing. Mr. Bennett was a known stroke patient. He had been suffering from confusion, rapidly deteriorating health in the months preceding this day of February the 12th, 2021. On this fatal night, Mr. Bennett exited the Walmart at the intersection, and he entered onto U.S. Route 19, traveling southbound in a northbound lane, going the wrong direction on a 4-lane highway. At the Sheetz gas station, just across the intersection, which is a local known hangout for some of our younger kids, the bystanders actually saw this gentleman enter onto the wrong side of the highway. Those bystanders attempted to flag Mr. Bennett down. They pursued him for miles on the opposing line of traffic, honking their horn. I submitted some video footage. That video footage has been submitted to Mr. Kirby by email. If any of you would love to see that video footage, he has that email. It's video footage of one of the bystanders who entered his vehicle and attempted to flag Mr. Bennett down. For miles, Mr. Bennett ran car after car after car off of the road in near-fatal accidents until he ultimately involved a head-on collision with my daughter and Philip Dickerson, killing all 3 of them on site. This was Philip's 19th birthday. They're close family friends of mine. They're a good family. We're a good family. I want to reiterate to you all that she's not just a statistic. She's your daughter. She's your granddaughter. This could be your mother. This could be your father. This could be your grandparent. She was beautiful. She was articulate. She was intelligent. She was caring. And she had her whole life ahead of her. She loved photography. She modeled. She was passionate about animal rescue. Words can never describe the beauty of this child. In that single moment, I lost one of the few lives that mattered to me more than my own. Her smile, her beauty, her intelligence, I wish you all could have had an opportunity to meet her because she would have been something great. We also lost Philip. Philip is known as Phil the Thrill for his love of life. He was charismatic. He was funny. He was an absolutely unforgettable young man. And please, let's not forget that we lost Mr. Bennett, a pillar of his community, a good, outstanding man who literally was just suffering from a medical diagnosis. We have a tight-knit community. We're very grateful that our community surrounded us and sheltered us in our time of need. But you have 3 families devastated by this one accident. We lost my daughter. Another family lost Philip. And another family lost a father and a grandfather in Mr. Bennett. In the days following that accident, it was revealed that Mr. Bennett had rapidly deteriorating health, like I mentioned. He'd been involved in other recent minor vehicle accidents just weeks preceding this fatal accident. One such incident involved a local business owner who found Mr. Bennett confused, cognitively impaired, operating a vehicle near his personal business, which was J&J Supply in Ansted. Mr. Bennett was unable to operate his truck. That truck had drifted into an embankment. The business owner asked for a phone number or an address to take him home. He couldn't provide either. The business owner was able to put Mr. Bennett in the passenger seat, and Mr. Bennett was able to direct him back to his home. He drove Mr. Bennett back to the home. His family members reported that although they had considered taking his keys, they struggled with removing the last form of independence that he had, which was his ability to drive. Once again, I feel compelled to say that accident could have been prevented. Within months, I was shocked, absolutely shocked, devastated to be advised that another young lady, Miranda Browning, also from Oak Hill, her mother, Melissa, will speak to you in just a few minutes, was tragically killed in a very similar accident. Her vehicle was struck in a head-on collision by a driver traveling the wrong way on the same U.S. Route 19. I was devastated by that news. I was flooded with emotion of loss all over again. I seemed to be reliving those days and those moments following my daughter's death, and all I kept thinking that once again was this accident could have been prevented. I indirectly knew Miranda, but you see, it's a small world. In just our tiny little area in Fayette County, Miranda and Michaela were actually friends. Miranda taught my daughter how to do her makeup. She would frequently do her makeup for prom, her hair for prom, for pictures, that type of thing. Michaela looked up to Miranda as a friend and as a mentor. The two shared many of the same interests, including photography. Another family lost a wife, a daughter, a sister to an accident that could have been prevented. Although I don't know the intimate details of that accident, I cannot ignore the obvious similarities that stand out. We all have an obligation to ensure the safety of our drivers and that of the surrounding community as well. It's a difficult conversation to have, I know, but it's a conversation that has to take place. Inevitably, skills and abilities of driving tend to deteriorate with certain medical diagnosis. Although it's strongly recommended that medical professionals report potentially unsafe drivers to the DMV, it's not required currently by law. It's only a recommendation, not a requirement. Had the proper requirement been established, his medical professional should have reported him unsafe to drive. His family, too, held an obligation, not only for his safety, but for the safety of others as well. Since Michaela's death, I have had 2 more personal incidents happen. My mother was involved in a horrific ATV rollover accident, and she suffered severe head trauma, 4 months in the ICU, a long recovery process at home. Do you think any medical professional ever reported her to the DMV for the removal of her driver's license, temporary? No, they didn't. My father is recovering from bladder and prostate cancer. When he went under the knife, he had a stroke in his eyes. Do you think a medical professional has ever reported him to the DMV for further evaluation of his driving capabilities? No, they haven't. But I stepped up. Families struggle with removing that last form of independence. I get it. It's the medical professional's responsibility to ensure not only the safety of their patients, but the safety of our community as well. Currently, 12% of the states require physicians to report. Obviously, West Virginia is not one of those. I urge each of you today to review and enact this legislation by law, mandating by law, that healthcare professionals be required to report potentially unsafe drivers to the DMV for further testing, further evaluation, as deemed necessary for their patients. This is also for the safety of the public. There is a DMV program in place called the Medical Review Unit, but I repeat again, it's a recommendation, not a requirement. A simple change can save a life. That simple change could have saved the life of my daughter. It could have saved the life of Philip Dickerson. It could have saved the life of Mr. Bennett. It could have saved Miranda Browning. It could have saved Mr. Smith. 2 incidents that happened in a short time frame within 5 miles of each other. Our neighboring state of Pennsylvania has such a law already in place. In fact, your proposed legislation closely models that existing law. I'm asking you all to take a proactive approach in addressing this instead of a reactive approach when we deal with your family's next death. Don't ever say it can't happen to you. It can, it may, and I'm here to testify to that. She had her entire life ahead of her. She deserved a chance at life, and I ask you to make the change.
Thank you, Ms. Kirk. With
Gentleman seeks leave to call
Yes.
one other witness.
Yes,
You may proceed.
thank you, Mr. Chairman. Melissa Buttrick, please.
Would you introduce yourself, please?
Hi, my name is Melissa Buttrick. I'm Miranda Browning's mother.
All right. Ma'am, do you swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Ms.
Thank you.
Ms. Buttrick, thank you for being here.
Thank you.
Again, I cannot even imagine how difficult this is, and I've asked for some leeway for you to be able to share your story with this committee
Thank you.
without interruption.
Thank you very much. Amber hit all of the points. There's a few things that I would really like to add, and some of the things that were said kind of struck a chord with me. So this might answer a few things as to where I personally, myself, am coming from. In June of 2021, my family owns the Christian bookstore in Beckley. My parents, Mike and Kay Teener, own that. My father came down with glioblastoma, brain cancer, stage 4. It was very, very quick. It came on very quick. In fact, we had no sign that there was anything wrong with my dad at all. When the doctors told us what was wrong with him, he was having seizures at that point. He was having hallucinations. The nurse in the room said for him to probably not drive. His license was not revoked. A few days after that, my dad thought he could drive. He wanted to drive. My dad was a strong, independent man. He's the dad, you know, he takes care of everything. Imagine being able to have to tell your father that he can't do something. Okay? I was blessed. My father trusted me, trusted my mother, my brother, didn't argue with us. But as I work every day in a Christian bookstore, I have so many people that come in and we talk about things and we communicate. I cannot express to you the number of families who deal with this issue. They don't want to have to tell their parents, their sisters, their brothers, anybody, even their younger children that have problems, that they have to take their liberties away from them. More than likely, especially if you're dealing with a parent, parents don't listen to their kids. I'm sorry, they don't. They're in charge. We can take their keys away from them. We can take their car away from them. But when they hear the doctor say, "I'm sorry, I have to do this," it's the law. Sometimes that resonates. It also takes the blame and the control of them losing their independence away from their families, who are the ones that are trying to protect them and keep them safe. In the situation with my daughter was 22 years old, had been married for 2 years. She was a photographer, a published photographer. As Amber told you, she was a makeup artist. She also, her and her husband both, cared very much about people who had ailments, so much to the point that my daughter and her husband both did respite. They took care and drove people who could not drive to get their medicines, to be out in communities shopping, to aid in the things that these people need. My daughter worked for her aunt, who is mentally challenged, and my daughter took her everywhere she needed to go. My daughter's husband did the same thing. These were people that understood that families needed help in these areas. On the night that my daughter was taking her payroll into her job, she was driving from Fayetteville toward Beaver. A gentleman came up the wrong side of the Bradley exit, came at her going 72 miles an hour, they estimate, and hit my daughter head on. She was going around 65. My blessing is, excuse me, my baby died. I don't have to worry. Excuse me. That she felt pain. In this situation, I know, I'm sure all of you have children, and I will tell you, and you hear it over and over and over again, there is no greater pain than losing a child. I lost my dad 6 months before I lost my daughter. I was a daddy's girl. I grieved for my dad, but nothing like my daughter. All she ever wanted was to be a mother and take care of a child and be a wife and take care of her family. The man that hit my daughter also wanted the same thing out of life. The people that came into my store and told me how wonderful of a man he was, and for me not to hate him. How can I hate somebody? How can I be bitter? It's someone, it wasn't their fault. He had been told many times he had cognitive problems due to diabetes, issues with diabetes. It caused a lot of confusion. In fact, the night that his confusion was messed up, he had been at church. He was just at church. Just wanted to go to church, coming home from church. These gentlemen lived in these communities. It's so far from not knowing the roads. They grew up in these communities. They know people. This was medical. He was a good man. I've never heard one cross word about him. For people to come to me knowing that that man was responsible for my daughter's death and look me in the eyes and tell me that he was loved and he was a good man says a lot about the man that hit my daughter. It also tells you he needed to be protected. He needed to be protected from himself, and he needed to be protected to protect my daughter. My son-in-law was greatly affected by my daughter's death. He lost his place of rental. He had to come and live with me. He lost my daughter's income. They were just starting their life. And I've wanted to show how much that affected his life as well. I just want everybody to understand that there's so many different paths to passing this law. Nobody wants to take anyone's independence away from them. Nobody wants to take civil liberties away from people. All we're asking is for people to pay attention, for doctors to pay attention and see what is going on. Before I came to speak today, I dug up a little bit of statistics with Health and Human Resources, and I found some interesting things. One of the things that stuck out to me was by the year 2025, the Department of Health and Human Resources is estimating that 50,000 people in West Virginia would probably be diagnosed with just Alzheimer's. Just Alzheimer's. There's dementia. There's all kinds of side effects from severe strokes, in my case, severe diabetes, that cause severe cognitive issues. that affect driving abilities. When you think, well, that's just 50,000 people, here's the other statistic. Out of 30 people that have Alzheimer's, now this is just Alzheimer's, 47% of those people will be involved in a car accident that is because of their cognitive issue. In my opinion, that's a very high percentage. I think even if it may not be Russian roulette yet, I think it's headed that way. And I think that we have an obligation to society, to our communities, to our children, to our parents, to everybody. And I know that everybody in this room has got somebody in their family that is going to or does need their help now. And I'm sure that everybody has something. They see a failing parent or something. At some point, we have to make the right decisions to protect people, love them, care about them, because people who have cognitive issues, they already think you're out to get them. They already think you're a bad guy. They already think that you're taking their money. They already think these things. Why do we protect mentally challenged people? The reason we protect them is because they can't protect themselves. They don't have the mental capacity to be able to make those decisions. That's where the really hard parts come in, and we have to make those hard decisions. If we love West Virginia, we love our families, we love our children, we need to not just be words. We need to be action. We need to show people, and yeah, West Virginia might be a little state, but I think we're capable of leading by example of what it means to take care of each other and protect. And I think this is a good start. I thank all of you for listening to me and my time. Appreciate it. Thank you.
Thank you, Ms. Buttrick, and I'd like to thank the chair and the committee for taking a few moments and pausing and listening to these stories. Thank you, ladies.
Thank you. We'll return to questions of council. Are there any other questions of council? Does any other member seek leave to call a witness? Gentleman for the 42nd.
Yes, I would call the DMV commissioner.
Commissioner, if you would please take the microphone. You can share this microphone right here. Would you please introduce yourself, and I will swear you in.
Everett Frazier, West Virginia DMV Commissioner.
Thank you. Do you swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you for being here, Commissioner Frazier. And have you had a chance to go over the committee substitute?
I have been briefed on it. I have not read it, but I know enough about it to elaborate a little bit.
Okay. Right now, it's kind of permissive as to whether or not a healthcare provider reports to you guys that someone is suffering from some type of disorder that's impairing their ability to operate a motor vehicle. So right now, it's permissive, but this bill would make it mandatory. Can you tell us, when you receive one of those permissive reports, what is your office doing?
And I have my expert here, Debbie Ferguson, and she can correct me if I'm wrong. We contact by letter the citizen, and we bring them in for retesting.
So as part of that retesting, that includes some form of medical evaluation, whether it be the eyesight test or something like that? Or would it also be the driving portion of the licensing exam?
That would be dependent on what kind of condition would be submitted to us.
So that's kind of in the discretion of your regional directors at that point?
Correct.
Okay. You know, we've heard talk from the witnesses about mainly mental impairments that, you know, we hate to see it. All of us have grandparents and parents that, you know, I don't think there's a family in here that hasn't seen somebody go through a cognitive decline. And one of the first questions that comes up with the family is, should we really be letting them drive? And, you know, other issues associated with the DMV, with the elderly, like the silver alert system and things like that, how does this law play into that, or the change that we're proposing to make play into that?
I think it's very simple. If we knew about it, it wouldn't be on the family to take mom, dad, grandpa's, whomever's driver's license. That burden of proof would be put on the DMV.
Okay. And based on my reading of the bill, you're getting a report from the physician. I mean, the physician's getting mandated to report this, and basically you guys are going to revoke that driver's license at that point, or suspend it at that point. And the one thing I don't see in the bill is some way to appeal it, but just based off my understanding of the law, anything you guys do is appealable to circuit court right now anyway, right?
Correct.
Okay. So that doesn't necessarily have to be in here. If someone wanted to challenge that, or maybe get a second result or something of that nature, they could pursue that through circuit court, it seems.
To my knowledge, yes.
Okay.
Or the medical advisory board.
Yes, the medical, and that's part of your department, right?
Correct.
Okay. The language that we talked about earlier on page 3 includes but is not limited to. That language there, and you know, I've known you for a long time, but I think me and you both know you're not always going to be the DMV commissioner. By us having that language in there,
thanks, Brandon.
I'm not saying we want to get rid of you, brother. I just, I love you just as much as everybody else does in here. But, you know, if a new DMV commissioner will come along sometime in the next 50 years,
thank you,
they might change how they feel what falls into that category, and that permissive language includes but is not limited to, could suddenly put a lot of otherwise decent drivers at risk due to a difference of opinion about what could medically impair somebody. I mean, am I wrong about that?
I would concur with you, sir.
Okay. I have one last question, and that hasn't come up in here, and as an attorney that's worked in just about any type of field we can, I like to call myself a general practitioner, probably much like the chairman does. We handle a little bit of everything, but I've been a mental hygiene commissioner before, and you know, the interesting thing about that is you can find somebody incompetent and we can immediately take their firearms rights, but there's no immediate taking of a driver's license. When I was a mental hygiene commissioner, you know, that's always bothered me, and I'm not saying that we need to amend this bill to throw in mental hygiene stuff, but would you be opposed? I mean, CDL drivers have to go and get physically qualified all the time, you know, to drive on a vehicle. You know, the FAA requires physicals every year, you know, for somebody to be a pilot. Is there anything, I've thought about this issue in the past, is there anything wrong with us saying every 10 years you need to get a medical checkup to see if you're still fit to drive? I mean, do you see an administrative problem with that at all?
Are you asking me this question?
Yes.
Technical questions.
From a technical standpoint, is there something that well, I mean, he kind of runs the place, you know.
I know. Technical question about the bill.
Well,
Explain your amendment here.
all right, we'll get there. Okay, no more questions. Thank you, Your Honor.
Mr. Frazier. Thank you, Mr. Frazier, very much for being here.
You're welcome. Thank you.
Any other members seek leave to call a witness? If not, are there amendments? Lady from the 71st, gentlelady from the 71st.
Thank you, Mr. Chairman. I'd just like to ask to take leave to ask council another question.
Proceed.
Council, on, let's see, it's on page 1, on line 1, and under the article 17B 313, it says, unless contrary to federal law. What would be contrary to federal law? What falls there? What falls under that?
There could be some mental health provisions that aren't disclosable or able to be disclosed pursuant to HIPAA. Involuntary commitments, things of that nature, may have certain state and federal requirements, require confidentiality of care and provisions of that nature.
Okay. Thank you.
Yes, ma'am.
Gentleman from the 88th.
Thank you, Mr. Chairman. Council, I recognize this is a law that would only affect West Virginia, and we can't impose our will upon our neighboring states, although I suspect, like myself, an awful lot of our drivers actually get their health care out of state. I see doctors in Maryland and Virginia, and none in West Virginia, coincidentally. But my question is, with regards to the definition of a health care provider, does that include, say, a spouse or somebody like that? Or are
you
they
saying
exempt somehow, maybe by federal law? So my first wife had cancer.
Yes.
And I think at times I was called her health care provider.
Are you licensed in anything that's under Chapter 30 of the code?
Not to the best of my knowledge.
Okay, okay.
So there would be an exemption as a family member?
And I think the question would be asked, so are you talking about like a husband-wife situation where, let's just say the wife is a doctor and the husband
I hadn't
has
even
some
gone
sort
that far. It's a great question.
and the husband maybe suffers from some cognitive impairment, would the spouse be under an obligation then to produce a report? Would that be the question you're asking?
Yes, sir.
I think you hit it when you said, do they fall under the term healthcare providers, and are they treating and diagnosing the diseases of the spouse? I think that would probably be where that question turns, in terms of the spouse. I agree.
Which would probably be unlikely in most cases. I think there's probably some medical code that you shouldn't be treating your own family members.
I would think that would be the case, but.
Okay.
Yes.
Thank you. Appreciate it. Thank you, Mr. Chairman.
Any other questions, council? Gentleman from the 76th.
Thank you, Mr. Chairman. First of all, in the requirement that we have here, does it really have any teeth? Because it says that they shall report. It also says later on page 3, in subsection G, that compliance or failure to comply does not constitute negligence. And I don't see any other criminal penalties or other any other way that you can compel a medical provider to do what it says in this bill.
Okay, so I would think that licensure would be something that you could allege a violation. So if a doctor, I'm just going to use a generic doctor, if a doctor were to know that this type of cognitive impairment exists and chose to ignore the requirements of this statute, and unfortunately one of the hypotheticals is demonstrated today through the testimony were to occur, that I think the family could file a licensure action against the doctor stating that they didn't follow the mandates of this law. And I think that doctor would be subjected to some questions and some due process around the status of their license to practice medicine.
Okay, so I guess the remedy, if somebody were to violate this, would be a complaint with the medical board or the osteopathic board or whatever licensing board the person practiced under.
Yes, the only thing I would add is that is a section that was already existing in the code, this type of language. And yes, I think that would be the remedy that a family would have to seek if they wanted to take this decision by the doctor to the doctor. Yes.
Okay. Second thing, as the way the bill reads, because I know that the gentleman from 42nd brought up treatment itself, but the fact of someone being diagnosed with alcoholism, substance use disorder, or mental health disorders, does that make them automatically someone who needs to be reported to the DMV?
If a doctor would define those types of disorders, and I don't have a DSM-V, I think it's 5 now in front of me, that shows the requirements for diagnosis, okay? But if those were to meet the definition of a cognitive or mental disability that would affect the ability of a person to drive, then yes, they would fall under the purview of this committee substitute.
Okay. I would assume if a doctor had his or her license potentially at issue with a complaint, and there was the possibility that one of these issues might, in general, make someone a dangerous driver, then they're more than likely to do this report.
I think they would be more than likely to do the report in that situation, sir.
Had a question about whether that would potentially, if people knew that they would be reported for being diagnosed with substance use disorder, alcoholism, and they knew if they went to seek treatment that they would automatically be reported, would they not go to receive treatment?
I mean, I think that absolutely could be something that were to occur. You know, substance use disorder is a prohibition on gun ownership, for instance. They'll ask if you're a habitual user of drugs or if you suffer from addiction when you apply to buy a gun. I don't mean to take it there, but and a lot of people will avoid getting, and I've read about this anecdotally, they'll avoid getting any type of medical marijuana dispensed to them because they don't want to have their gun rights impacted. So yeah, I think that policy creep in this instance could impact someone's willingness to get treatment.
No, and I certainly don't want to take away from the seriousness of the stories that have been told today. I think it's our job, especially when we have situations that come to us because of terrible, awful facts, to make sure that we're vetting what we're looking at very thoroughly, but also making sure that, again, not necessarily the bill itself, but the wording that's in the bill and the effect of the bill is not going to have a bad outcome. And the outcome I'm thinking of is we have lots of laws against driving under the influence. We have laws against driving intoxicated with certain substances. And so depending on how we define the diagnoses that would be reported, it's possible some individuals would not get treatment and therefore might be more likely to drive intoxicated, and that would be something that could end up killing a person. I don't know that I have an answer right now. It's just something that, in reading the bill, I'm thinking about. That's all that I have. Thank you, Counselor. Thank you, Mr. Chairman.
Other questions of council? Gentleman from the 5th.
Thank you, Mr. Chairman. Council, follow up on those questions. Subsection F states that a healthcare provider who makes a notification shall be immune from any civil, administrative, or criminal liability. And administrative is where you're getting it to the license issue, presumably. It would be an administrative ruling. It would be in front of an administrative judge, things of that nature, with like the Board of Medicine. That's if they report currently.
I think that it could be arguable Administrative could be Administrative Practices Act. There's a little bit of vagary there. Could be subject to an amendment to clarify at that point in time, or clarify that issue.
And that is if you are compliant and make a reporting under subsection F. But then you have subsection G, which states that compliance with or failure to comply, in other words, you did not report, does not constitute negligence, nor may compliance or noncompliance with requirements of this section be admissible as evidence of negligence in any civil or criminal action. Don't those conflict? Meaning if you fail to report, shouldn't you have some risk of liability and admissibility for negligent act?
I guess, so Section F is an immunity provision. An immunity provision would be a complete bar to suit, whereas in G, compliance or non-compliance does not constitute negligence. One could argue there could be maybe another cause of action that's outside of the world of negligence.
I've been practicing law for a few years now. If there's failure, you're an attorney, you're our counsel here, providing an opinion. It's pretty clear that if you fail to have negligence, you fail to really have standing to bring a suit.
There could be intentionality.
You would be in very rare circumstances, you would be able to find intentional conduct. So my point is, based upon just the plain language of subsection F and G, I just feel they conflict. And if we're looking for this bill to have teeth to it, right? We had great testimony here today, and we want to make sure that we're incentivizing compliance. And my point in subsection G is, if we can't say you were negligent and not complying, how are we incentivizing those individuals to comply with the law? That's
the response I would have for you, sir, would be one.
Policy question.
It is yes. Two, it's existing code, and that already exists. And yes, you got the first one. It's a policy question, and that's
I
why
would agree it's
here.
existing code, and that's why we're here to fix it.
Yes,
right now.
And gentleman's free to offer an amendment.
Thank you.
Any other questions of council? Gentleman from the 86th.
I'm not sure if the council's going to be able to answer this, or it goes back to DMV, but so based on this code or proposed law, the physicians or other healthcare professionals will make a recommendation to or a report to the DMV, but then the DMV, it falls on their shoulders to determine whether or not this is a disqualifying offense, or does that automatically lead to the revocation of a driver's license?
So I will say that under the West Virginia Code, this ComSub would require the report to be made to the Division of Motor Vehicles. Then you turn to 17B36, which is the authority of the division to suspend, restrict, or revoke license. And the division is hereby authorized to suspend, restrict, or revoke the driver's license of any person without preliminary hearing upon a showing by its records or other sufficient evidence that the licensee, and there's several examples, but the one that applies here is incompetent to drive a motor vehicle. So once the report is made, then it flows to the Division of Motor Vehicles to direct what next steps would be taken in regards to that license. They can do it based upon the records and the evidence submitted by the doctor without preliminary hearing. Now, that being said, there's also another provision, which 17B37, which they can require some reexamination in this instance, and require the licensee to submit to further testing. So I'm sure that the commissioner can probably go into their responsibilities and how they implement this much better than I can, because that's what they do for a living. But that's the code on what is required to happen.
Okay, thanks.
Yes, sir.
Other questions, council? Gentleman from the 75th.
Thank you, Mr. Chairman. Council, thank you for being here. Quick question. On the com sub on page 2, lines 32 over to 42, to follow up on my colleague from the 76th, heart-wrenching stories we heard today, my God, our heart goes out to all of them. But at what point does it say the doctor has to tell the family of the patient? This says tell the patient, tell the patient, tell the patient, and how to avoid negligence. But at what point does the personal responsibility go to the caretaker or the family of that patient? Because oftentimes, to the young lady's comment, they told the gentleman, and he's not going to want to give it up. If no one else knows about it, he comes out and tells his wife, I'm fine, everything's good. Is there anything in state code that says they should be reporting that to the families or the caretakers of that individual?
So there's a lot to take in there.
Sorry.
So there's some privacy laws that we have in effect, which would prohibit the doctor from disclosing this to family. Is there some sort of guardianship over the affairs of this individual that would authorize the doctor to disclose to the family? Of course, so with that all in mind, the code is drafted that you tell the patient because of these privacy laws that exist, and that is why I would offer, that is why the code reads tell the patient and not the family. Because it would conflict with other federal laws and other state laws about privacy of medical records.
So I guess the follow-up then, so we can't tell the family, but we can report it to the DMV?
Correct.
Okay, thank you.
Other questions of council? All right. We have amendments. Any other amendments? I'll try to get these in the order that I received them. Gentleman from the 42nd seeks to amend the bill, page 3, subsection H, by striking the words includes but is not limited to, and inserting in lieu thereof the word means. So it would read, for purposes of this section, diseases, disorders, disabilities, or conditions means physical impairment, etc. Gentleman seek leave to briefly explain his amendment.
Yes. One of the things, being in this business for 6 years now, that I have come to learn is the phrase includes but is not limited to allows for a bureaucrat to expand something beyond the legislative intent rather easily. And while I do love our DMV commissioner, and I think he is wonderful, we have to think about not who's there, but the position itself. And as a legislature, especially in this situation, I think we need to be very, very clear about what we're talking about, because different people could come up with different things that we did not intend. And if it becomes necessary for us to include something else in here that maybe is not in there, I think it's pretty comprehensive right now. I think we got some mandatory reporting. I think it's talking about physical, mental, cognitive impairments. I would hate to see someone become an activist and try to throw something else in there. So for that reason, I would ask your support for this amendment to remove that expansive language.
Questions of council regarding the amendment? Questions of council? Are there amendments to the amendment? Discussion. Discussion regarding the amendment. If not, all in favor of the gentleman's amendment signify by saying aye. Aye. Opposed, no. The ayes have it. Gentleman from the 42nd Amendment is adopted. Next, we have an amendment from the gentleman from the 55th on page 3, section 13G, line 43, and there is a competing amendment from the gentleman from the 5th. The gentleman from the 55th seeks actually, I do not believe they are competing. The gentleman from the 55th seeks to add after the word action the following language. Nothing written, or I'm sorry, nothing within this section prevents investigation and/or enforcement by any boards or licensure bodies such as something professional discipline. Gentlemen, help me out there.
Hate to tell you what it says. Sorry about that. Yeah.
Just read it entirely, please, if you would. That he's wanting to add language after the word action on line 43.
So after criminal action, it would continue with a new sentence that says, or that reads, nothing within this section prevents investigation and/or enforcement by any boards or licensure bodies such as for professional discipline. Although, well, I don't want to get ahead of myself. That's all.
So let me explain to you, the gentleman from the 5th seeks to strike G as it exists in the code, lines 41 through 43. The reason I do not believe they are competing, if the gentleman's amendment striking G succeeds, then, and also the gentleman from the 55th amendment succeeds, then the gentleman from the 55th amendment would just simply replace G. So that's why I don't think they're competing. So we'll take up the gentleman from the 55th amendment first. The gentleman seek leave to explain his amendment.
This is just to clarify. I know we had opinion from counsel earlier that he still believes that a licensure board could still perform an investigation or enforcement action, although if I'm a lawyer for a physician in this situation, I would probably argue that as it currently reads, it states that any evidence of compliance or failure to comply shall not be evidence of negligence in any civil or criminal action. There's only two types of actions you can have before court, either a civil or criminal action. This would be potentially an administrative action, which is still civil. So I just want to make sure that if a physician, for example, or medical provider is still subject to licensure review, that we've made that clear within this new code section. Although I think I probably, Mr. Chairman, may have to reform my amendment, because then when I look back at section E, current section E, it also states that, I'm sorry, section F, it states that a healthcare provider who makes notification shall be immune from civil, administrative, or criminal liability. In current section G, as proposed, states compliance or failure. So I would move to reform my amendment so that we add the words for non-compliance at the end. For non-compliance. Non-compliance. The very end.
After the word, his word discipline, it just adds for non-compliance to his existing amendment.
Correct. So in anticipation, if a physician complies, there should be no professional discipline, but non-compliance could subject the provider with discipline, or to discipline.
Very well. I will try. After the word action, nothing in this section prevents investigation and/or enforcement by any boards or licensure bodies such as, I still don't get this.
provider, and also non-compliance or compliance does not constitute negligence. That would have to be modified as well. Yep. Yep.
Other questions of council? Amendments to the amendment? Discussion, gentleman for 40 seconds.
I've got to agree with the gentleman from the 5th. I'm glad the families are still sitting in here, and I know this had to be really confusing. I know there had to be times where you're looking at me like, what in God's name is he getting ready to do to my kid's bill? And I'm sorry you had to watch us make the sausage. Sometimes it's tough. But if we don't go with this man's amendment right now, this bill is meaningless. It is absolutely meaningless. It will do nothing but make them feel good until they walk out the door. And I live down in Beckley, and I practiced in Fayetteville, and I think some of you actually know me. And how many times have we seen trucks cross that lane? How many times have we seen this? And it's going to keep happening. And then when it happens to one of our neighbors, we're going to look at them and be excited and say, hey, they fixed this. But who do you sue? The person that crossed the line that has $25,000 of state minimum coverage? Is that going to replace her pre-med student? No. Is that going to replace the young man that everybody loved, who's going to be a big part of his community? No. But what you could do is follow the Malpractice Liability Act. You can go get a screening certificate of merit, and you can find out, based upon whether or not this doctor complied or didn't comply with what was going on, and you will pay your $5,000 or your $10,000 to get yourself a screening certificate of merit, to get a neutral doctor to say whether or not this person did comply before you can even file suit. And then you can go through your mandatory mediation and everything else before you can sue a doctor and get a maximum of $750,000. What this bill says right now is that we're naming something after Michaela, Miranda, and Philip. If you leave G in there, that's all this bill says. It does absolutely nothing. Because to a physician that messes you'd be suing them for the policy limits. If this was a corporation that put their employee in a bind, put them in a bad situation, and killed him or her, you'd be able to cause of action. But we're talking about someone not complying with the law, getting immunity for civil liability for the death of these children. It's obscene. And I know there's a lot of times that we want to agree with the gentleman from this time. He is 100% right. 100% right. This does not work with G in there. And I think the gentleman from the FISC work on this makes this meaningful. It gives it bite, and it will go a long way to making sure that we're making sure that drivers on the road are safe, and that if physicians are seeing something, they will have a duty to report it. They will train each other on it. Their lawyers will tell them about it. Their insurance companies will make sure that they are doing mandatory education about it. We won't even have to tell them to do it. If those physicians are liable, that evidence can be introduced against them. All we're saying is you can introduce the evidence. We're not saying whether or not they win the case. We're not even saying whether or not they get a screening certificate of merit. What we're saying is use the evidence. Where in the world, out of the entire code, I've never seen a place that says you can't use that as evidence. We have never done that. Never as a legislature being of telling a court what competent evidence is and what it's not. That's where we start crossing the lines of our culture. So I'd urge each and every this amendment, or else this bill is meaningless. And the parents and the families of Michaela, Miranda, and Philip Wasted a trip up here. Thank you, Mr. Chairman.
Other points of discussion? Discussion. If not, all in favor, signify by saying aye. Aye. No. The ayes do have it. The gentleman from the Fifth Amendment is adopted, and the gentleman from the 55th Amendment will become the new subsection G. All right. Gentleman from the 8th to move the committee substitute as amended.
Thank you, Mr. Chairman. I move that we report committee substitute for House Bill 4315 as amended with the recommendation that it do pass.
You heard the gentleman's motion. Is there discussion?
Thank you, Mr. Chairman. I would like to say that to the mothers that were here today, your conversations make us uncomfortable, but we have to listen to them. We have to listen to them. They make us feel uncomfortable. We have to do something. And I would say that we will before we leave here today. We will make a statement. Also, to those listening and to the mothers that are here, you heard a discussion that's taken a couple hours probably. And typically, we are arguing back and forth with the gentleman from the 5th. But that's not the case today. What you've seen here is an effort to make this bill better by everybody around this table, and to make the work product something that we can work with moving forward. So I want to tell you that so you understand, and I want to thank the committee for working so diligently on this evening. I know it's taken a lot of time, but we're ready to make a statement now. Thank you, Mr. Chairman.
Thank you. Gentleman from the 42nd.
I would echo everything that the Vice Chair has said about today's debate, and I know it took a lot of time. I do have one amendment sitting in front of me that I withdrew, and it's something that I want to bring up because I do think that this is a good first start, but is it going to catch everything? Is it going to take another set of parents to come in and tell us another story before we go the full way? And essentially what I was going to propose to do is that every licensed driver in this state, regardless of endorsement or restriction, is subject to a physical every 10 years. You start at age 15, you get them at 25, you get them at 35. We do it to CDL drivers, we do it to pilots, we do it to everybody else. I mean, to me, if we're talking about people's personal safety, and we're talking about the safety of drivers on the road, and we're talking about losing what was probably going to be a huge contributor to our community based off what her mother told us, it's not that hard to go down to a chiropractor's office or a nurse practitioner or MedExpress and get you a quick physical, get your eyes checked and everything else. I mean, my goodness, I've been driving for over 25 years. And not one time has the DMV checked me to see if I'm still capable of driving. Thankfully, I think I am. But when do we start that? And I hope we'll continue to work on that. I don't know if people are supportive of that idea or not, and I most certainly didn't want to try to insert something in this bill that would kill it, so to speak. But I will probably send it down to bill drafting, and maybe it's something we take up and maybe it's something we don't. But I'm afraid that if we don't continue to go after this problem with the way that our population is aging and the substance abuse problem that our population has, and we drive on some of the most dangerous roads in America, it may not be this set of parents or family members that shows up, it's going to be other ones. And And I hope we will continue to go down this road. Thank you, Mr. Chairman.
Gentleman from the 44th regarding the bill as amended.
And I couldn't agree more with what the delegates before me have said, and I won't belabor the point, but I want to thank the families for being here today. You all got to hear a piece of their story, or part of their story. Myself and the delegate from Fayette, who is the sponsor of this bill, have been in contact with these folks going on almost 2 years now. As a matter of fact, some of the first conversations I had once I was elected to the House was with this family and this group of families. And so I want to thank them for their passion and their stick-with-itness, because I know there were times when they got very discouraged. I'd also like to thank the chair and this committee as a whole for taking the time to take up this bill and to make it a better bill than it was when it came to us. Thank you, Mr. Chair.
Other points of discussion? If not, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed, no. The ayes have it. I declare that committee substitute for House Bill 4315 as amended will be reported to the floor with the recommendation that it do pass. Ladies and gentlemen, we've been at this 5 hours now, and it's almost 7:30. We are going to adjourn, and the remaining bills on our agenda will be put on Wednesday's agenda. I can't say Wednesday's going to be a short meeting, because we need to move all these bills, and we have tons more to do. So, and I apologize for people like my county clerk, Michelle Hawley, is here, and I'm sure she's here to offer technical expertise on some of these elections bills. We just did not anticipate this day going so long, but so having said that, council, thank you. Look to the gentleman from the 8th for a motion.
Thank you, Mr. Chairman. I move we adjourn.
All in favor, signify by saying aye. Aye. Opposed, no. The ayes have it.